from supplementary list for face filing. Item 1, DT.04.08.2026.
Annexure 2, page number 20.
Two out of 9 witnesses have been examined.
Only 2.
That's right. When was the charge frame?
Yes, the charge has been framed
On 19/3/26.
19.
Yes.
Victim and mother of the victim also.
We have separate judgments.
Kindly see para number 20.
We cannot hear to appreciate. Victim has been turned hostile.
नहीं हॉस्टाइल नहीं है मेरा, लेकिन हमारे साथ 4 से 5 महीना हमारे साथ शादी करके रही है। शादी करके हमारे साथ
पॉक्सो में है
केस इसी नहीं है, पॉक्सो भी नहीं
है मतलब पॉक्सो में चार्ज फ्रेम हुआ है ना।
अब वो चीज तो कोर्ट ले
चार्ज फ्रेम हुआ है ना पॉक्सो में।
चार्ज फ्रेम हुआ, लेकिन उसका एज खुद बोल रही है, उनकी माँ बोले कि हम लोग बच्ची का
एज से
नहीं, माँ का एज कहने से नहीं बोले कि हम बढ़ा के लिखाएंगे। और डेट ऑफ बर्थ है मिनट 10/6/2006।
कहाँ से निकाले हैं डेट ऑफ बर्थ?
डेट ऑफ बर्थ
तो डॉक्यूमेंट है।
PW2 का डिपोजिशन पैरा 30। पीड़िता को स्कूल में एडमिशन कराते समय
PW2 का पैरा 30
पेज 32 में पीड़िता को स्कूल में एडमिशन कराते समय उम्र घटाकर नहीं भर्ती कराते थे, बल्कि दिनांक 10/6 को स्कूल में दाखिले के समय लिखा है। और हमारे साथ 4 से 5 महीना रही है। और पैरा 23 में शादी भी हम किए हैं।
The bail application of the petition was rejected by real on CBA number 3051 of 2026 by order dated 15/2026. Further submits that the victim as well as his mother has been examined and as per the mother, the date of birth is
10/6/2006.
uh, 10/6/2006.
विक्टिम खुद बोल रही है कि उसको 4 से 5 महीना।
However, the victim has stated that her date of birth is 6/6/2006. However, from the petition of the deposition of the victim, that is that she has stated that her date of birth is 6/6/2006. Transpired that the charge has been filed on 19/3/2026, and out of 9 witnesses, 2 have already been examined. Till 23/6/2026. After meeting the learned counsel for the charge has been filed under section 65 with bracket 1, 87, 351 with bracket 2, 352 of BS, and also under section 4 and 6 POCSO Act. And trial is in progress. And the bail application of the petitioner was rejected on merits. Although this petition has been done to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses are accommodated. Also for the state is directed to communicate this order to the SP of the concerned district and to the director of distribution. Office is directed to forward a copy of this, a soft copy of this order. आपने इसमें ये बाद में आने का क्या मतलब है? You get sentence in time. You get various record for the years of course of law.
Item 2, DA6754 of 2026.
Sorry. Pass over yesterday also it was passed over. Okay, there is direct application against you. Isn't it? No means
also the petitioner and the informant, they both had it. First they met at the gym and after that they had established sexual relationship. Informant has appeared also.
informant has appeared and has stated that compromise. What are the terms of compromise in a rape case? What are the terms of compromise?
पहले वो बोली कि जेल भेजो
आप compromise का क्या कहानी बोल?
तो आउट ऑफ द कोर्ट सेटल करो
क्या सेटल करेंगे? वही तो हम जानना चाहते हैं।
साथ रहना चाहते हैं साथ में
कहाँ है terms of settlement? लेकर आएंगे। ये सब कहानी आप क्यों मोटा appear हुए? What is the terms of settlement? रेप केस में settlement होता है? क्या settlement हुआ? शादी हो गया है दोनों का? What are the terms of settlement?
अकॉर्डिंग टू द विक्टिम लॉर्डशिप से आप लोग साथ रहना चाहते तो निकाल दीजिए
कहाँ लिखे हैं? साथ रहना चाहते हैं निकाल दिए हैं शादी हो गया कहाँ लिखे हैं? Yes.
सेटलमेंट लिया
पिटिशनर जेल में बैठ के सेटलमेंट कर He's so powerful in a rape case.
although it is not compromisable
Sorry.
this compromise is not compromisable in this case
So,
but victim according to
so you're influencing the victim. What else? उनका examination हो जाने दीजिए उसके बाद आइए. Court में examination.
Both are major,
So what?
It's a consensual relationship, whatever happened.
Compromise का कहानी कहाँ से आ रहा?
Compromise.
What are the terms of settlement?
They are showing आगे शादी कर लेंगे वो हमारा.
कब कर लेंगे? बताइए हम शादी करा देते हैं provisional bail आपको देते हैं शादी कर. बताइए terms of settlement.
दोनों के फैमिली वाले चाह रहे हैं कि बाहर आके मिलके.
वही ना कोई बात नहीं आपको provisional bail देंगे शादी करके.
Very long 3 साल 4 साल से वो लोग उसकी रिलेशनशिप में.
कोई बात शादी करना चाहते हैं ना शादी करने के लिए आपको provisional bail देंगे. आप affidavit फाइल करिए दोनों जने terms of compromise लेकर आइए. The informant has appeared in this case and it has been stated therein that they have settled the dispute outside the court. The learned counsel for the parties have submitted that they want to get married to each other. The learned counsel for the parties are directed to file supplementary affidavit in this regard. चलिए शादी करना है शादी करा दो. Post on 25th of August. The supplementary affidavit should be filed by 21st.
For admission, item 3, DA5725 of 2026.
There is a allegation in FIR that the petitioner is alluring the daughter of the informant to take for purpose of marriage. And thereafter, FIR lodged on 21/12/2025. And
क्या बोल रहे हैं?
during investigation, the victim has jamin, and I have a statement of 180 of DNS. She has stated she went with petitioner and Chhattisgarh and working as a labor work, and she has stated that the petitioner has committed sexual abuse.
बहुत डायरेक्ट एलिगेशन रूम में बंद करके रखते थे और क्या बोली
हाँ इतना
छत्तीसगढ़ में जाकर
हाँ।
एंड शी इज माइनर
लॉर्डशिप माइनर का कोई एविडेंस नहीं है जो जो
चार्ज
During-
किस सेक्शन में फ्रेम
चार्ज अंडर सेक्शन 6 में हुआ
है ना
हाँ लेकिन लॉर्डशिप जितना केस डायरी आया है उसमें देखा जाएगा डेट ऑफ बर्थ हैज नॉट बीन प्रूव्ड बिकॉज वो केवल 7-8 क्लास का एक सर्टिफिकेट ला दिया गया है कि हाँ इनका एज इतना है जबकि जो लॉ है जो न्याय जस्टिस है वो कहता है कि बिगिनिंग या फिर मैट्रिकुलेशन का सर्टिफिकेट इज द मैंडेटरी
तो आप
व्हिच हैज नॉट बीन फॉलो
आप पूरा प्रोसिक्यूशन का क्वेश्चन करें
नहीं जो ग्राउंड है यही
जो
बोल सकते
ग्राउंड
हैं
पे
जो
जो आप
मेरे
बहस
पास
कर रहे हैं उसका उपाय बता दें हमें
जी
और the learned counsel opinion the the learned counsel for the petitioner has submitted that the petition is in custody since 21/1/2026 and it is alleged that the petitioner had taken the victim to Chhattisgarh and committed sexual assault with her. This means that no document regarding the age of the victim has come up during investigation. And although the charge has been framed under Section 6 of the POCSO Act also, the learned counsel further submits that the age of the victim has been taken from the document relating to class 8. The learned counsel for the state has opposed the prayer for hearing and has submitted the counsel for the informant is present. You are supporting? You want him to be bailed? Opposed. आजकल सपोर्टिंग डिटेल ज्यादा आ रहा है अभी सपोर्टिंग बेल में 2-3 चीज और करने वाले हैं। पहले तो विक्टिम का बैंक अकाउंट हमको लेना पड़ेगा और लेना पड़ेगा कि वो विक्टिम कॉम्पनसेशन ली है कि नहीं, ये दोनों चीज बहुत जरूरी है।
स्टेट
बहुत जरूरी है विक्टिम कॉम्पनसेशन लेके हॉस्टाइल।
वैसे जो जेन्युइन केस है उसके लिए तो हम कहेंगे कि उसको रिजेक्ट होना चाहिए
विक्टिम कॉम्पनसेशन लेके हॉस्टाइल जब होता है विक्टिम तो बहुत सीरियस बात है।
बहुत सा केस में ये भी होता है ना विलेज में कि अगर कोई इनिमिटी है उसके लिए भी एक
वो
केस
अलग बात, वो
करा
अलग
दिया
बात। विक्टिम कॉम्पनसेशन लेके
हाँ
हॉस्टाइल
वो
होना
गलत
तो
है
सही
वो
नहीं है।
SC/ST में भी यही हो रहा है बस एक FIR
The
लॉन्च
learned
करके
counsel
FIR
appearing on
is
behalf of the informant has opposed the prayer for bail. The learned counsel for the state has referred to the statement of the victim recorded under Section 183 BNSS, wherein the victim's age has been recorded as 14 years. To sum is that there is direct and specific allegation against the petitioner.
Para 97 of the case, there is the.
And in para 97 of the case diary, it has come that in
Para 97 of the case.
वही
para
उसी बेसिस पर
97
8
of the
क्लास
case
का जो
diary, the age of the victim has been mentioned as, the date of birth of the victim has been mentioned as 3/5. After hearing the learned counsel for the parties and considering the direct and specific allegation against the petitioner, this court is not inclined to enlarge the petitioner on the bail.
Item 4, DA.04.08.2026.
Yesterday also it was passed over. You are
Because वकालत आवाज फाइल करनी है।
Huh?
वकालत आवाज फाइल करनी
By whom?
है।
Informant.
Yes, he's there. So you argue.
Just asking for a fast, short fast. Mr. Sinha's arguing counselors.
So I should go to him. So Yesterday it was passed over. Today also we are seeking pass over. It was not passed over.
Item 5, BA 65810 of 2026.
I'm representing informant. I filed my local account.
The offense is under section 108 commitment to society. So technically notes the petitioner and the deceased were in love affairs with each other books, and just to pressurize the petitioner and the mother of the
Read the
informant.
FIR please. FIR please.
सरना निवेदन है कि मेरा नाम जयंती देवी पति खेत मोहन महातो ग्राम सजित पोस्ट इधर महातो थाना सुना हाथू जिला रांची की निवासी हूँ। आज दिनांक 15/8/25 को सुबह मेरी बेटी अमीषा कुमारी ने बताया कि विकास मुक्तु ग्राम सरमाली ने मुझे फोन कर बताया था कि तुम्हारा फोटो वायरल कर देंगे, जिसके चलते मैं बेटी के घर में फोन कर लगी थी और अपने बेटे को फोन कर सुना हाथू बुलाई तो जो गुंडू में रहता है, जहाँ से सरमाली विकास मुक्ति के घर गई, उसके घर में कोई नहीं। तो मैं वापस आने समय मैं अपने दीदी के घर रंगाडी गई, फिर अपने मायके डुमरीडी गई। शाम को लगभग 6 बजे मैं अपने घर सीधी पहुंची। घर पहुंचने पर मैंने देखा कि मेरी बेटी अमीषा कुमारी दुपट्टे से सबके बांस पर बंधी हुई है। मैं और मेरा बेटा मिलकर बेटी को कंधे से उतारा और बिस्तर पर लिटा दिया। उसके बाद खाना में
The photographs were made viral. The photographs were made viral. Have they been found?
This not viral. This photo has been sent to the mother of the victim. Only to the mother of the victim. This has come in the appeal order.
You have shared the photograph, isn't it?
Only to the mother, my lord, not to anyone. Not to anyone. Just to make the mother to get married her daughter with me, lords. Only this is the allegation. And this petitioner will kindly appreciate.
Sharing a photograph by itself is.
Lords, the photograph is not of such of nature, lords, not vulgar, lords. It's merely a photograph of both collide, lord. Not that of vulgar photo नहीं है वो।
ये जो पेज नंबर 13 में है, ये काफी बढ़िया फोटोग्राफ है।
Lords, दोनों एक दूसरे के साथ हैं, तो they are in love for last 2 years, lords, and petitioner is working in Bangalore, lords. इसलिए से घर में कोई भी नहीं मिला है। तो इंस्टिगेशन का आरोप मेरे ऊपर नहीं है हुजूर। शादी नहीं होने दे रही है लेडी, जिसकी वजह से उसने सुसाइड किया हुआ। Impugn order on page 23 by Iowa. Peruse the case record, it appears that allegation against the petitioner that the deceased was his girlfriend with the intention to pressurize for marriage. He sent their private photo to her mother. शादी के लिए तैयार होती तो वो सुसाइड ही क्यों करती? हम घर पे नहीं थे हुजूर, क्योंकि हम बैंगलोर में थे, बैंगलोर में काम करते।
This is not to the mother. The deceased girl is aged about 17 years old. He's also already denied to marry with this person, and she doesn't want to keep any relationship with it. It's come in the case diary.
17 years.
Yes.
Charge किसमें frame हुआ?
Yes.
Charge 108 and
66 and 67 of IT Act. But it's surprising to see that the charge has not been taken in POCSO Act.
Charge frame हुआ?
Yes, two witnesses have been examined, and two witnesses, and one is going to be examined on 12th of this August.
My lord, 3 months time may be given to conclude the trial. Lord, I am ready, Lord. हम 1 साल से कस्टडी में हैं हुजूर।
कब तक कस्टडी में?
17/8/25 से 17/8/25।
चार्ज का फ्रेम
8/1/2026।
कितने विटनेस एग्जामिन?
2 witnesses have already been examined.
Only 4 are to be examined, Lord. Informant has not been
out of 6, my lord. Out of 6, 2 has been examined. One is going to be examined on 12th of this August, my lord.
Lord, 3 months का observation दे दिया जाओ to conclude the trial, Lord. I am ready.
The learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 17/8/2025. Charge has been framed on 8/1/2026, and till date. Two witnesses have been examined out of 6 witnesses. He also submits that the charge has been framed for alleged offence under section 108, 351 within bracket 2 of BNS and under section 66(3) and 67 of the IT Act. The learned counsel submits that the petitioner had the petitioner wanted to marry the victim, marry the deceased, and for that purpose, he shared the photograph, the objectionable photograph with the mother of the victim. The learned counsel for the opposite, for the informant has opposed the prayer for bail and has submitted that the age of the victim
It's 17 years.
is 17 years.
It's reduced
per
as per the postmortem report.
as per the postmortem report. और कोई है एज का proof? और कोई एज का proof है?
Or to diary mason. I have given you that is the postmortem report.
But it is surprising that charge has not been framed under the POCSO Act. The learned counsel submits that it was a petitioner who had instigated the deceased to commit suicide, as he has shared the objectionable video / photograph with the mother, with the mother of the victim, of the deceased. The learned counsel for the state has also opposed the prayer for bail. After hearing the learned counsel for the parties and considering the nature of offence and also that the petitioner had shared the objectionable photo / video, which ultimately led to the suicide of the deceased. This court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. Next date कब है?
12th of August.
It has been informed by the learned counsel for the informant that the next date in the case is 12th of August. Counsel for the state is directed to communicate this order to the SP of the concerned district and to the
Lots
director.
some observation may be given lots. Unnecessarily, I am suffering lots. For last 1 year, lots.
नहीं आएगा witness तो आ जाएगी.
3 months का देती
Witness
है.
नहीं आएगा तो आ जाएगा. Witness नहीं आने पर हम नहीं देते.
From Delhi list for orders with effect item 1, BA file number 8901 of 2026.
Appeal can be granted notice for removal of defect notes insofar as defect note 54 are concerned notes. One defect is that is
Time till 21st August is
ignorable
granted.
minutes that may be ignored minutes. Defect note 54 minutes.
What is it?
That is the effect of enclosure minutes. The copies are provided by the learned court below that does not contain the enclosure minutes. So that may be ignored minute, please 14 minutes.
They are not provided in the
No minutes.
bank statement, Aadhaar card. They are not provided in that. The learned counsel for the petition submits that the defect number 54 be ignored in as much as by in view of the fact that while giving a copy of the FIR, the enclosures to the FIR, that is screenshot, bank statement, and Aadhaar card, etc., has not been provided. Considering the submissions, the defect in connection with defect number 54 is ignored for the present. That's all.
Within a week, I will remove that one. Rest of the defects. Within a
So
week.
far as other defects are concerned, a time till 14th August is granted to the petitioner to remove the defects. If the defects are removed on the time, posted on 20th August.
Orders item 2, BA 7123 of 2026.
Why is it for orders?
Para 2, I have noticed that the petitioner has a bill application also, in which by a file supplementary.
You did not state.
No,
What did you state? That you are not moving.
lost.
Why did you
But-
state so? Why did you state so? You have no responsibility.
Okay, I am not responsible, but to my mistake also I could not find out.
You can easily find out. कोई मुंशी भी find out कर लेता है. वहीं जाता है और वहीं से आ जाता है. Objection आने के बाद आप supplementary file करते हैं. पहले स्ट्रक्चर हो जाता है, पता है ना? अब तो आप काउंटर पे जाइए, you know whether you are moved or not moved.
It is my mistake also. When it has come to the knowledge that the merchant family, that we have a file supplementary. Rashtriya has also not pointed out. Later on he has pointed out. But I have had immediately lost.
On maybe out of 7,
I will not ignore this.
out of 7 witnesses, 2 have already been examined.
How many?
Out of 7, 2 has already been examined.
Two.
From the
Also, I have annexed the position of informant also.
आपका बाद में ना.
Informant is a CPW2 impact. Page 21 also. See case of 302 also. And he has stated in examination in chief noticing that in case मेरी बहन से प्यार करता था और साथ में रहता था इसलिए इसकी विरुद्ध केस किया. There is no eyewitness person. They were living in tenant house person.
The matter has been listed before this court as an instance of the office on account of suppression of fact by the petitioner in paragraph 2. It has been pointed out that the petitioner had filed bail application before this court earlier in VA number 11094 of 2024, which was rejected on merits by the order dated 9/1/2025. The learned counsel for the petition summons that the statement in paragraph 2 was made under mistake. And in such circumstances, a supplementary affidavit has been filed. There is a supplementary affidavit, the explanation furnished by the petitioner is accepted. The case has been argued on merits. The learned counsel for the petition submits that the petitioner and the deceased were living in as living relationship, and the petitioner is in custody since 5/1/2024.
I want to charge any friend on
Charge was framed on
3/6/24. 3/6/2024.
3/6/2024, And as of now, how many witnesses have been examined?
Out of 7, 2 witnesses have been examined,
And as of now, out of 7, only 2 witnesses have been examined,
including informant also. PWP is the informant,
including the informant.
brother of the deceased.
Who happens to be the brother of the deceased. Is hostile.
No, no.
Well,
Kindly
when it comes for the
please
state,
follow.
as opposed to prayer for bail, and I submitted that the sister of the informant died due to strangulation in the house of the petitioner. And both the petitioner and the deceased were said to
That was the tenant.
be living together. After hearing the learned counsel for the parties, it appears from the improved order itself. This court finds that the case of the petitioner was rejected earlier on merits. And the trial is in progress. And out of 7 witnesses, 2 witnesses have been examined. And the improved order reveals that non-bailable warrant of arrest has been issued against the other witnesses who are to be examined. दो witness कौन examined हुए?
One is
The 2 witnesses
Padum Sahu.
who have been examined are not the official witnesses.
No.
Meaning thereby, the official witnesses are also yet to be examined, but the prosecution is not releasing the official witnesses also for the examination. NBW issue 1. Since the case of the petitioner was rejected earlier on merits and there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. There can be no reason for the state for non-production of the official witnesses, right, before the court. The counsel for the state is directed to communicate this order to the ST of the concerned district and also to the directive prosecution, who would take appropriate steps so that at least the official witnesses are produced and examined.
Office filing item 3, VA 6597 of 2026.
Kindly see impropriety and absurdity, and the FR was done after 15 days. And this petitioner is in jail 9/3/26. Kindly allow me to take them along with the read the FR itself. That is misconduct.
पढ़िए
शरण निवेदन को कहना है कि मैं पूर्णिमा कुमारी पति संशोधन कुमार शर्मा ग्राम सरिता साहपुर थाना जयपुर जिला पलामू का निवासी, जो कि मेरे गांव के हैं, चुनू से कोई पिछले 2 दिनों से पिता भगवान सिंह ने जब मैं चापा कर पानी लेने की रात थी, उसी समय उठाकर मुझसे बोलता था आकर बोलता था कि मैं पानी नहीं भरने देंगे और जान से मार देंगे। इतना कहकर मुझे हाथ पकड़कर ले जाकर कहे कि घर में किसी को बताएंगे तो तुमको मारेंगे। Kindly see in the house, the place of problems, either my house or her house, and who are so many family members in the day. Secondly, kindly कहीं
रात्रि को 12 बजे
हाँ रात्रि के 12 बजे entire family members sleeping, all he went there and it is stated she is sleeping with her husband, all family members in the house. There is no allegation that any window or door was broken by him, and he entered and committed. And the first case that Chapakalola, no FIR. And after 15 days, he instituted the case. This is my number 3 report. Medical report also does not corporate of 9/3/26. Rest of occurrence is itself not. It is addressed, it is not mentioned. So many family members are good. And first offense, no, and second offense, no, only for the purpose to make offense, since it is a risk, you will institute it because they are good.
What is the age of the
डॉक्टर साहब जो है वो
चार्ज किसमें फ्रेम?
16 से 17
चार्ज किसमें फ्रेम हुआ? अब चार्ज फ्रेम नहीं हुआ।
हो गया सब सब चार्ज फ्रेम का थोड़ा बट चार्ज को 376
पॉक्सो के साथ 376 लगना और पॉक्सो के बिना 376 लगने में फर्क नहीं समझ में आता।
नहीं उसको भी लगा आई नॉट सेइंग दैट आई नॉट सेइंग
तो you say you just said she is 19 years.
नहीं 19 years आई एम बोला 16 to 17 years they are not included that is included here देखिए क्या बोल रहा है 14 16
Yes.
that is my submission also that is my submission
अब आपको सुन लिया, अब चुप रहिए, ठीक है? और कुछ बोलना है? हम सुन लिया। अब please maintain some silence on your side. Yes, you are for the state and informant. What do you have to say? आप informant है, कौन है आप?
इंफॉर्मेट है।
आपको क्या बोलना है?
ये एफआईआर जो है ये पहले घटना की है तो बाद में इस तरह से
उम्र 15 से 16 साल that is the 23 are you
Or the learned council appealing on behalf of the parties. The learned council for the petitioner submits that the FIR has been lodged on 29/1/2026 and there is enormous delay in as much as the last incident which has been mentioned in the FIR is 14/1/2026. The learned council submits that it is impossible that the petitioner could get into the house and commit the offence as at 12 o'clock at night, as all the family members were present in the house. Even
husband
husband of the
victim she is married
even the husband of the victim was present at home. The learned counsel for the petitioner has submitted that charge has also been framed under POCSO Act. And out of 11 witnesses, 1 witness has been examined so far.
subject to correction so one
Witness has been examined so far. The learned counsel for the state and the informant have opposed a prayer for bail and have submitted that the victim was minor and there is direct allegation against the petitioner in the FIR itself, and the victim is the informant of the case. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner in the FIR itself, and admittedly victim was minor on the earliest date of occurrence, this court, and also the fact that the trial is in progress, this court is not inclined to enlarge the petition on bail. Victim को examine कराइए उसके बाद
at this business
It is always at this stage.
victim some down no way.
ऐसा तो कुछ आप रिकॉर्ड किया है
ना तो अभी second time
Item 4, BS 6862 of 2026.
at this business
It is always at this stage. Where is the petitioner? Are you there in this case? Council for the petitioner place for not to be most amount.
Item 5, BS 6873 of 2026.
Case. The students is 95 that is corresponding to 498 of the same 61 that is related to the objects. So the informant daughter was married with this and at the time of marriage. So we are paid.
Date of marriage.
Marriage in the year 2024. So my case is more on the date of office, this petitioner was not present in the village, rather he was at Raipur. The statement of the brother of the informant of this deceased has been recorded. This petitioner was residing with his Sala.
Prior to the occurrence, the petitioner had a talk with the victim and
On
he has
phone.
been abusing
On phone, one
on
just said.
phone and abusing her.
No, but I was residing at Sala, we are doing the work of labor at Raipur since long. On the date of office, there was some talk between exchange of hot words between petitioner and his wife, as per the statement. The witnesses have said that the relationship was cordial. She hanged herself. This is not the case as she was assaulted. No injury has been found. No injury has been found by the doctor who held the postmortem examination.
There is no question of injury from your side because you were not there.
I was not
Admittedly, you
there.
were not there.
The relationship was also cordial. But that
How do
the
you say that the relationship was?
pardon?
How do you say? You see, the brother has said that you abused her on
Well-
phone.
Yes, ma'am. Page 3 of the impugn order.
Yes,
Page 3.
yes.
The brother of the deceased supported the case of the prosecution and has stated that on 11/7/25 in the night, this petitioner is staying with him in Raipur, Chhattisgarh, while with the deceased sister on phone. That is the
And then other
and he was pronouncing gali galos to her. Investigation is still pending. That's why I am submitting matters with me. As per the statement of all the villagers that the relationship was cordial, I was residing and I was doing the work of labor outside of the state with my Sala.
Is there any allegation of doubt?
No, there is no demand.
Read the FIR, please.
Diary is used to maga ke as per my
FIR
section.
पढ़िए.
Yes, ma'am. Page 10. आगे कहना है कि मैं अपनी पुत्री सचिन सच की शादी सचिन सच के साथ मई 2024 में हुई थी। उस समय लड़का पक्ष से एक अनुरूप नगद सचिन सच अमाउंट दैट वाज डिमांडेड शादी किया गया था। मेरी पुत्री एक ही थी जो दिनांक 12/7 को समय रात्रि 2 बजे मेरी पुत्री प्रभा देवी उम्र करीब 20 वर्ष तो उसका पति देन ही हैज नेम्ड ऑल द पर्संस। सभी लोग मझियाओं जिला गढ़वा के रहने वाले द्वारा एक राय होकर मांगा गया दहेज 1 लाख रुपया नहीं देने पर उक्त 6 व्यक्ति ने बेरहमी से मारपीट कर हत्या कर दी। दैट इज द लिमिट। As per the first information report that I also
You also used to demand.
well, all the six 1 लाख रुपए जो मांगा दहेज के रूप में नहीं देने पर वो 6 व्यक्तियों ने बेरहमी से मारपीट कर and subsequently he says मेरी बेटी को पैसा को लेकर के प्रताड़ित करते थे ससुराल वाला और उसकी ननद फिर हत्या ही कर दी। He is not making specific allegation against me and against me. The allegation is that I was residing outside of the village matters. with my Sala, who happens to be the brother of the deceased, and they were doing the work of labor. And on the date of offense, there was some exchange of words with the deceased and the petitioner of that justice. I have been made. There is no specific, and the investigation is going on. Whereas the charge sheet has now been submitted because he is in custody since 4/5/2026. And the doctor who held the autopsy examination has not found any sign of.
This what you have to say.
ना ऊपर डायरेक्ट एलिगेशन है सभी ने गला दबा के
With the husband ने तो गला नहीं दबाया ना, husband
हस्बैंड ने फोन पर एक रात पहले जिस रात का घटना है फोन पर आया है कि भाई अभी थे बहुत बुरा भला केस डायरी में स्टेटमेंट में है कि गाली गलौज किया कि नहीं तुम पैसा करेंगे तो तुमको सब मार देंगे और फिर उसके दूसरे दिन गला दबा करके मार दिया
parties. The learned counsel for the petition says that marriage between the petitioner and the deceased was solemnized in the year 2024, and she was found dead in matrimonial home on 12/7/25.
Yes.
12/7/25.
Yes, 11/11 को.
On 11/11/7/25,
Yes, but there was talk, an exchange of words on the 11th.
the learned counsel submits that the brother of the deceased has stated that the petitioner was with the brother staying at the Raipur, and therefore there is no doubt that the brother of the victim, the petitioner was not present in the place of occurrence. The learned counsel has also submitted that there is general allegation on all the family members with regard to demand of dowry and torture. And it is alleged that the family members assaulted the deceased and she died. The learned counsel for the informant has opposed the prayer for bail and has submitted that the brother of the deceased, though was at Raipur along with the petitioner, but he has stated that on 11/7/2025, in the night, the petitioner had a quarrel with his wife and he abused her. He has also submitted that the petitioner along with others used to torture the deceased on account of non-fulfillment of dowry, which was to the extent of ₹1 lakh. After hearing the learned counsel for the parties and considering the allegation of demand of dowry made in the FIR itself, and charge has been framed for and the case has been registered under section 80, 85 and 61
Charge
of BNS. Charge under which section?
No, charge has not been framed.
Investigation अभी चल रहा है.
Chal raha tha, usme when the bail was refused on 5/6 mallards, and my also submission is mallard, the doctor who held the postmortem examination mallards, he has not found any external injury.
That's right. The deceased having died within 1 year of marriage, and there is allegation of demand of dowry. This court is not inclined to enlarge the petition on bail against the husband and his widow.
Well, refused at this.
So
Well, refused at this.
it is always at this stage.
Because the investigation was going on, liberty be given mallards that after conclusion of the investigation of framing of charge, he made news
Not
there.
required.
What evidence has been collected during investigation? Because the main allegation is with regard to the assault.
Item 6, BS
No
6
injury has been
2006.
Main allegation is not assault.
No,
Main
that is an
allegation
assault.
is-
And that is against the sister-in-law.
96 investments and 4 hospitals. The first information report has been lodged after 5 days. And page 60 is the first information. Girl is aged around 17 years old.
Also, for the state is directed to serve notice upon the informant. The statement of the victim reported under section 183 variances will fall for the concerned court along with the case diary and its enclosures. The counter affidavit will be filed by 21st of August, based on 27. So it's 27.
Item 7 BS 6879 of 2026.
The state is directed to serve notice upon the informant of this case. Charge का framework. Charge का framework.
2025 में वो जो 21/7/25
The counsel for the petition submits that the charge has been filed on 21/7/25, but no witness has been examined. So the state is directed to file a counter affidavit in this case. And explain as to why the witnesses are not being produced before the court.
No.
Let the state of the case be, let the present state of the case be also called for from the concerned court, along with the case diary. Victim का statement record हुआ होगा ना? The statement of the victim recorded under section 183 BASS. And also the medical report of the victim.
No.
The counter affidavit will be filed by 21st portion.
No.
आपको witness भी produce करना है। 2025 से। ये state
Yes,
SC/ST का केस है।
SC/ST.
हाँ? क्या कर रहे हैं आप? Only 3 witnesses are there.
Out and out of false case.
Maybe false case, but they are bound to produce a witnesses.
Milord, they are bound.
1 year.
नहीं सकते हैं तो क्यों रखते हैं जेल में? मत रखिए।
FIR
नहीं,
में
SC/ST का केस में विटनेस नहीं आएगा।
Milord,
Item 8 BS 6885 of 2026.
Yes, petitioner.
Section 127 and 96 of the BMS, as well as 6 of the first one. Replace allegation for very short by running to 19 mechanisms. Running page 2.
ये तो मां ने FIR किया है ना?
FIR इसके
पिताजी इनका स्टेटमेंट रिकॉर्ड हुआ कि नहीं हुआ?
स्टेटमेंट रिकॉर्ड हुआ आप victim
आप लगाएं?
victim का स्टेटमेंट नहीं मिल पाएगा मैडम उसमें जो victim का स्टेटमेंट टोटली डिफरेंट है वो बोलते हैं कि 1 महीने
मंगा लेते हैं ना?
हाँ ठीक है मंगा लिया
The state is directed to serve notice upon the informant of the case and file counter affidavit on merits. Let the statement of the victim be called for from the concerned court along with the case diary with its enclosures.
इसमें चार्ज भी हो गया था, इसमें मेरा क्लियर था कि स्टेट ट्रायल साथ में आ जाता है।
And also the stage of the trial. The counter affidavit will be filed by 21st post on 27th August.
Item 9, PS 6887 of 2026.
So the matter relates to cybercrime. First time we touched on this. One mobile phone.
Charge sheet तो नहीं हुआ।
ऐसे के तो दिन में होगा मुझे इसको अगले
ये
वीक
यही
काउंटर
आपकी
के लिए
गलती है ना। आप लोग यहाँ पे वेट करते charge sheet हो जाए। So for the first time we will examine the case diary. ये मतलब है क्योंकि स्टेट क्योंकि वो लोग तो केस डायरी नहीं एग्जामिन कर रहे होंगे, कैसे एग्जामिन कर? What material has been collected? हमारे कोर्ट को बना दिए ट्रायल।
नहीं
फिर क्या?
केस डायरी तो आता ही होगी बट इंटायर इन्वेस्टिगेशन कंप्लीट
केस डायरी भाई
मेरे पास
साइबर क्राइम में पूरा इन्वेस्टिगेशन ही नहीं आएगा।
नहीं आया केस डायरी है वो जो लेकिन पूरा इन्वेस्टिगेशन कंप्लीट नहीं हो जब तक चार्जशीट सबमिट नहीं
और रिव्यू ऑर्डर में ही लिखा हुआ है कि दिस केस इज इनिशियल स्टेज ऑफ
इनिशियल स्टेज
तो जो आ जाएगा 19/5
नहीं वही तो बोल रहे जब आ जाएगा तो हम पहली बार ही ना मटेरियल को एग्जामिन करेंगे। कोर्ट तो नहीं किया एग्जामिन तो हमको बना दिए ट्रायल कोर्ट।
जो नहीं जो
दिस
इसमें
इज
एक
नॉट
प्रॉब्लम
फेयर, यू सी दिस इज नॉट फेयर। साइबर क्राइम में सारा मटेरियल नहीं आता।
ठीक है 3 महीने के बाद ही अब फाइल करेंगे जो भी केसेस
हाँ,
आएगा
भाई, कम से कम
मुझे
चार्ज
लग-
शीट होने
हम लोग तो
दीजिए,
कर
गलत-
देंगे मुझे एक प्रॉब्लम हम लोग तो कर देंगे बट कोर्ट में इतना दिन तक लोग रुकना
नहीं
नहीं
कोई
चाहिए
बात नहीं, हम तो यही ऑर्डर कर देते हैं। अभी चार्ज शीट नहीं हुआ, अभी हम नहीं सुनेंगे।
नहीं तो इसमें तो आ जाएगा इसको अगले वीक अगर काउंटर के लिए करेंगे तो आ
नहीं, क्यों
जाएगा
करें हम काउंटर के लिए? BA number 6887 of 2026 for the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petition is in custody since 19/5/2026. And during the course of hearing, it transpired that the investigation is still going on and charge sheet has not been submitted. The learned counsel for the state has opposed appeal for bail and has submitted that since the investigation is going on, the materials are yet to be collected against the petitioner. Considering the fact that the investigation is going on and it is a case of organized crime, this court is not inclined to announce a
ऑब्जर्वेशन तो कम से कम चार्जशीट के बाद तो फाइल
आप आइए आप फिर से ये गलत है।
ठीक है,
This is
नहीं-
not being fair. तुरंत आज ये कल फाइल कर दिए, आज कस्टडी में आए, कल फाइल कर दिए, उसके बाद यहाँ आ गए, फिर यहाँ बोलेंगे 3 महीना बाद केस है। गलत है ना?
तो इसमें कुछ
Item 10,
observation तो
BS
चार्जशीट के बाद तो
6890
आप
of
आइए,
2026.
आपको पता है इन्वेस्टिगेशन स्टेज में आप चार्जशीट के बाद आएंगे, हम केस डायरी मंगा के आओगे, आप फिर से मूव करके आएंगे, दोबारा मूव करके आइएगा। Yes, petitioner. इस FIR इसी पर्टिकुलर ऑर्डर से और भी केसेस हैं आज लिस्ट में है?
मेरे पास तो एक ही है।
नहीं इसमें है एक और इसका है।
अभी जो हम किए हैं,
हाँ।
इसमें 4 केसेस फाइल हुआ है बट आज है कि नहीं ये नहीं देखा जो 4 केसेस
मेरे पास एक केस है।
ठीक है कोई बात नहीं। Yes, please.
It has been registered under section 1031 of the 5. I am not named in the FIR, Your Worship. My name has come in the confessional statement of the husband of the deceased, Your Worship. And I have also confessed before the police. I have annexed my confessional statement.
The state is directed to seek, the council for the state is directed to seek instructions and file a counter. Sorry, this is the best करना है। चलिए क्या है बताइए। Yes, madam. Up to date डायरी है ना?
Yes.
With all enclosures.
Yes. चाची ने मुझे अपडेट नहीं की।
आप बताइए क्या? Your name has come in the confession statement
Statement
of
of the husband of the deceased.
the husband of the deceased.
And I have also confessed my guilt before the police, which
That's right.
but I have annexed that confessional statement if I am permitted to do that.
Where is it?
It is at annexure 2, relevant would be page 19. मेरा नाम राम कुमार पूर्व सचिन निवासी मैं हाई स्कूल कुचाई से मैट्रिक तक पढ़ाई किया हूँ। पढ़ाई के बाद अपने घर में एक राशन दुकान खोला, उसी से घर का भरण पोषण होता है। वर्ष 2025 के दिसंबर माह से पहले ही मेरी दिनेश मानंडी जो कुचाई थाना में सिपाही है उससे मुलाकात हुई। दिनेश गांधी अक्सर मेरे दुकान के पास गजपति दास के दुकान में आता जाता था, वहीं पर उससे जान पहचान बना। दिनेश गांधी ने मुझसे बोला कि मैं एक बहुत बड़ी समस्या में फंस गया हूँ, उस समस्या को दूर करना चाहता हूँ। उसने मुझे बताया कि चाईबासा से कराईकेला थाना अंतर्गत कृष्णनगर गांव के रहने वाली श्रीमती गांधी से पहले उसका प्रेम प्रसंग था, लेकिन वर्ष 2015 में वह लड़की झगड़ा झंझट करके अपने मायके चली गई, जिसके बाद वह कभी नहीं दिनेश गांधी के साथ नहीं रही। दोनों के बीच सामाजिक स्तर से समझौता हुआ, जिसमें दिनेश गांधी को 12,000 रुपया प्रति माह श्रीमती गांधी को देना पड़ रहा था। घटना के पिछले 2 वर्ष से दिनेश गांधी इकरार किए गए पैसे श्रीमती गांधी को नहीं दिए, जिसके बाद श्रीमती गांधी को चाय थाना जाकर अपनी बात रखी, जिससे दिनेश गांधी काफी परेशान हो गए और मुझसे बोला कि मुझे श्रीमती गांधी को जान से मरवाना है, जो भी कीमत लगेगा वह देंगे। जिसके बाद माह दिसंबर के अंतिम शुक्रवार के दिन मैंने दिनेश गांधी को धनसी मुंडा से मिडिल स्कूल के पास मिला।
That's what we have seen. Is there any recovery on your confession statement?
Not on my confessions.
Whose confessions? Because it says that प्रयोग में किया गया लोहे का रॉड पुल के पास झाड़ियों में फेंक दिया और चुचाई अपने घर वापस चली।
मुझे उसके बाद अगर अगला पन्ना में जाएंगे तो कहता रॉड से धनसी मुंडा मुखिया ने मारा था, हमने मारा
नहीं, ये जो है the use of this particular weapon rod has been recovered on your confession.
Not on my confession.
So on whose confession it has been?
It has been stated in the case that मिल गया, मैंने ये नहीं कि किसके confessional statement है,
दिखाया सर,
लेकिन मिल गया।
बताइए कोई मनी ट्रांजैक्शन है?
Money transaction to that is not coming in the diary books. But your
किसके confession पे weapon मिला है?
it has come in the diary also that this petitioner Ramkumar Kumar was also in that associate, and your Dhansi Munda has your assaulted. Dhansi Munda has assaulted the deceased by means of a rod.
So you are supporting the Bela.
No, not supporting your.
What is the material against the petitioner?
Because all the 3 persons have your also made planning and they have gone to commit murder. Your also.
At whose instance the weapon has been recovered?
That will come your.
और जो हम सीजन लिस्ट में लगाया उसमें बोलता है लोहा का रॉड नहीं मिला है, खून लगा हुआ कॉटन कपड़ा लकड़ी में लपेटे, ये पेज 14 में
आप देख लीजिए, हमको डायरी आपको डायरी पढ़ने नहीं आ रहा, लाई दीजिए। Give me the diary. लोहे का रॉड और खून का नमूना दोनों ही रिकवर।
जो केस डायरी में वो लिख रहे हैं, लेकिन सीजन लिस्ट में दूसरा चीज।
सीजन लिस्ट में रॉड का रिकवरी नहीं,
खून का लगा हुआ कॉटन कपड़ा लकड़ी में लपेटे, पेज 14 में मेरे।
सर को पूरा कुचल दिया गया है नहीं? Petitioner is Ram Kumar.
जी
Council's opinion on behalf of the parties. The learned counsel for the petitioner submits that the allegation against the petitioner is that the petitioner was hired by the husband of the deceased to kill the deceased on payment of rupees 2 lakhs. There are other accused persons also. The learned counsel has referred to the confession statement. She submits that the petitioner is not named in the FIR and his name has transpired in the confession statement. He further submits that as per the confession statement also, the deceased was assaulted by the co-accused and not by the petitioner. She further submits that the weapon has not been recovered at the instance of the petitioner but has been recovered at the instance of the co-accused namely Sahdev Munda, who had taken the police where the weapon was kept. The learned counsel has submitted that no money trail has been found during investigation. The petitioner is in custody since
4th February 2026.
4/2/2026. Any antecedent?
No antecedent.
Having no criminal antecedent. The learned counsel for the state has opposed the prayer for bail. However, the reported submissions made by the counsel for the petitioner is not in dispute. कुछ गलत बोले हैं क्या?
Also associates of contemporary.
And he has submitted that the petitioner was associate of the persons who had committed the murder of the deceased. He has also submitted that upon a query of this court, he has submitted that no money trail has been recovered. After hearing the counsel for the parties and considering the associate submission, the name of the petitioner having transpired in the confession statement, and the petitioner being in custody since 4/2/2026, the petitioner is directed to be imposed on
Obligation.
Item 11, DA 6897 of 2026.
Cyber crime. Petitioner surrendered before the police. In this case,
ये जो आपके पास से जो रिकवरी दिखा रहा है, आपके
हमारे-
पास से नहीं है, ये सारे फोन किसके नाम से है?
हमारे नाम से,
आपके नाम से नहीं,
हमारे सिम भी हमारे नाम,
कुछ भी आपके नाम से नहीं।
मेरे नाम, मेरा कोई क्रिमिनल एंटीसीडेंट भी नहीं और सबका बेल हो गया। यहाँ तक कि एक और जिनका नहीं पकड़ाए थे उनका भी एंटीसिपेटरी बेल हो।
ये जो इनके ये जो इनके पास से बोल रहे हैं कि ये पास से थे और भाग गए हैं, इनमें से कोई भी इनके फेवर इनके पास से रिकवरी है क्या? इनका कोई भी जो मोबाइल या सिम है इनके नाम से है क्या?
कोई खिलौना, मतलब कोई खिलौना नहीं।
इनके पास से रिकवरी कितना रैंक नाम से
नहीं नहीं, रिकवरी इनके पास से नहीं है, ये तो भाग गए। ये मोबाइल सिम जो भी चीज है ये इनके नाम से है कि किसके
चार
नाम से?
मोबाइल और सिम है।
किसके नाम से है?
ये नहीं है लेकिन समझदार है कि इनके नाम से
नहीं,
कस्टडी कब से आपका?
कस्टडी हम सरेंडर किए हैं अभी रिसेंटली 2 महीना
चार्जशीट तो
पहले।
नहीं हुआ।
चार्जशीट नहीं हुआ है, लेकिन हम सरेंडर किए अपने से, क्योंकि हमारा एक का एंटीसिपेटरी बिल ऑनरेबल कोर्ट के द्वारा दे दिया गया था। हम उसी ग्राउंड में गए क्योंकि हमारा विथड्रॉ हो गया था, हम ही किए थे केस को फेयरली।
अभी तो
बोले थे कि
investigation ही नहीं complete
इन्वेस्टिगेशन
हुआ।
सबका इसमें हमने सबका ऑर्डर शीट इस पे लगाया हुआ है सारा।
इन्वेस्टिगेशन आपका कंप्लीट ही नहीं हुआ, तो फ्रॉम द प्लेस ऑफ अकरेंस से भाग गए। ठीक है, अब ये जो मोबाइल है वो आपके नाम से है कि किसके नाम से है, ये कहाँ से पता चले?
हाँ ये वाला आया हुआ है उसमें
कहाँ आया हुआ है?
सप्लीमेंट्री केस डायरी इसमें ऑलरेडी है देखना है।
सप्लीमेंट्री केस डायरी अभी तो आपका 9626 से ही आपका स्टडी में, वो किसके नाम से है ये?
हमारा नहीं
ये मोबाइल ये सिम किसके नाम से है?
नहीं
कहाँ लिखे हैं कि आपके नाम से?
ये इनको बताओ
आप बताइए ना।
नहीं है कहीं नहीं
ये जो इसमें जितना भी मोबाइल एंड सिम है आपके नाम से नहीं है
नहीं है
इनकी?
मैं हमने लिखा हमने इसमें किया है नो रिकवरी है
नो रिकवरी तो नहीं है, रिकवरी तो नहीं है, बट
जी।
whatever mobile and SIM was found at the place of occurrence from where you ran away, none of them belong to you.
पारा 8 पारा last two paras there is no allegation of cheating, non mentioning of any victim, not any statement of any present. There is no recovery of any income from the position. Rather, the alleged mobile phone recovered from the place of occurrence was blamed to be the mobile phone of Arif Ansari, and he has no concern with this phone nor its transaction.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner was not apprehended on the spot. Rather, it is alleged that the petitioner ran away from the place of occurrence and left his belongings. The learned counsel submits that
नहीं ये हमारा
none of the mobile slash SIM which is alleged to be of in possession of the petitioner before he ran away from the place of occurrence belongs to the petitioner. He submits that the petitioner is in custody since 9/6/2026 and admittedly he was not arrested from the place of occurrence.
all the other
The
co-accused
petitioner has no
criminal
criminal antecedent. The learned counsel for the state
and all the other co-accused have been granted.
submits that a number of co-accused have been granted bail by the Supreme Court.
My name came with some confessional statement of the co-accused. He has been granted bail.
The name of the petitioner transpires in the confessional statement of the co-accused. He has also been granted. The learned counsel for the state has opposed the prayer for bail. However, the fact that the petitioner was not apprehended on the spot is not in dispute. After hearing the learned counsel for the parties and considering the fact that the petitioner was not apprehended on the spot and other co-accused
Annexure 2 series.
as contained in Annexure 2 series have been enlarged on bail slash anticipatory bail. The petition is directed to be enlarged on bail. Since the petitioner has submitted that he has no criminal antecedent and no counter affidavit as such has been filed in this case, the learned court shall call for a report from the state with regard to the criminal antecedent of the petitioner. If any antecedent is found, the petitioner shall not be released.
Item 12, BA 6903 of 2026.
The first information report has been lodged under section 69 and 89 of the BAS. This is a case of two major persons in a consensual relationship on the pretext of marriage. If your lordships will go through the first information report, it is apparent that they both were in consensual relationship. Yes. सविनय निवेदन पूर्वक कहना है कि मैं सुनेंसो चतरा की निवासी हूँ। मैं वर्ष 2024 में अपनी चचेरी बहन के ससुराल ग्राम सचन से जिला चतरा एक शादी समारोह में शामिल होने हेतु गई थी, जिसमें शादी समारोह के दौरान मेरी मुलाकात उमेश उरांव जिला चतरा से हुई। मुलाकात होने के बाद हम दोनों में परिचय हुआ तथा उमेश उरांव मेरा मोबाइल नंबर सचिन सच को ले लिया। जब मैं देवलगड्ढा से अपने घर ग्राम सचिन सच आई not serious, not 1 5 from now. Both the petitioner and the informant are married as well. I've annexed the wedding. First information report was lodged. Thereafter, they both got married, and thereafter he was taken into custody.
Third, the learned counsel separating on behalf of the parties. The learned counsel for the petitioner submits that on the face of the FIR itself it is apparent that the petitioner and the victim were related and there was an element of consent with respect to the relationship. He has referred to annexation 2 and has submitted that the petitioner and the victim have also solemnized marriage and they are living together. However, the petitioner was taken into custody in view of the FIR.
No antecedent term is law
The
of
petitioner
CCL.
does not have any criminal antecedent.
Paragraph
The learned counsel for the state who has opposed the prayer for bail has opposed the prayer for bail. However, sorry, and has submitted that
Para 32 of the case diary,
the para 32 of the case diary reveals that
183 of the victim because
the victim has supported the prosecution.
Yes.
After hearing the learned counsel for the parties and upon going to the FIR, there appears to be some element of consent when the initial relationship was developed between the parties. In view of the aforesaid facts and circumstances, to this counsel for the petition, the counsel for the petition has submitted that the charge sheet has already been submitted. And since the charge sheet has already been submitted, the petition is already to be judgment.
Item 13, BA 6904 of 2026.
This petition.
Yes, is on the side. Lawsuit, police has not.
Investigation is still going on.
Lawsuit charge sheet has been submitted on
When?
31st, 2026. It is such. So police has first arrested accused Mohit Kumar and subsequently he has taken the name of this petition and on the position of this petitioner his mobile phone was recovered. This petitioner has no criminal antecedent. He is student of college nursing.
Counsel for the state is directed to file a counter affidavit. Bringing on record the materials connecting the petitioner with the alleged offence. And particularly the details in whose name the recovered articles from the petitioner are standing. The counter affidavit should also indicate the criminal antecedent of the petitioner as to whether any case has been registered against the petitioner in the state of Jharkhand or in any other state depending upon the crime names. And also the details of the victim who might have been identified. The counter affidavit will be filed by 21st or 26th.
Item 14, BA 6905 of 2026.
With one for the consent. Along with some papers. Yes.
66 and 67 of IT Act में उसको एक्ट करें फोटो वायरल करने का एलिगेशन है पेज नंबर 14 पेज नंबर 18 में
विक्टिम का एज क्या है
विक्टिम का एज 17 साल उपयुक्त विषय के संबंध में कहना कि मैं सुनीता देवी मदर
नाम
ये मदर विक्टिम का नाम नहीं है ये मदर का नाम
एक ही बात है ना विक्टिम का आईडी से डिस्क्लोज
अजय करंका पता सेक्टर 700 थाना सिटी बोकारो निवासी महोदय, मैं आपको बताना चाहता हूँ कि मेरी बेटी स्वयं सो एक अनजान लड़के से दोस्ती के लगभग 1 साल पहले हुई थी। दोनों के बीच बातचीत शुरू हुई। उस लड़के ने मेरी बेटी स्वयं सो का असली फोटो और वीडियो की मांग की। मेरी बेटी असली फोटो नासमझ थी और अनजाने में अपने फोटो वीडियो भेज दी। 2 महीने पहले से किसी बात को लेकर दोनों के बीच में बहस हुई और दोनों की बातचीत बंद हो गया। बातचीत बंद होने के उपरांत उसने सोशल मीडिया पर फोटो वायरल पोस्ट करने की धमकी दी और लगातार हमारे सभी रिश्तेदार, दोस्तों, इंस्टाग्राम आईडी स्वयं के माध्यम से सभी को भेज दिया गया। लगातार अलग-अलग नंबर से स्वयं से धमकी भरी मैसेज कर रहा है। अतः अनुरोध है कि इस मामले में एफआईआर दर्ज करें।
फोटो वीडियो रिकवर नहीं हुआ?
नहीं, कुछ भी नहीं रिकवर हुआ।
कोई रिकवर नहीं हुआ?
नहीं, कुछ भी नहीं।
चार्जशीट किसमें हुआ?
चार्जशीट तो हो गई,
किसमें हुआ?
उसको मंगाना होगा, विक्टिम भी एग्जामिन हो गया है, उनका भी स्टेटमेंट रिकॉर्ड हो गया। वो एक बार आप पेज 24 देखा ना, उसमें आया कि
The state is directed to notice upon the informant of the case and file a counter affidavit in this case on merits, particularly indicating as to whether the objectionable video of the victim has been recovered or not. That the statement of the victim recorded under section 183 BNSS be called for from the concerned court along with the case diary and its enclosures. The counter affidavit be filed by 21st, post on 22nd August. The counsel for the petitioner has submitted that the video/photograph has not been recovered.
as per the judgment.
Mobile was already recovered. I will file in court.
ऐसा नहीं होगा, लेकिन फिर भी एक समीक्षा थोड़ा रिकॉर्ड करना
ठीक है, जो
आगे फ्यूचर रेफरेंस के लिए
जजमेंट में जो है उसको हम देख के बता रहे 24 में रिकॉर्डेड
कोई बात
Item 15, DT.04.08.2026.
Allegation under section 126 to 115 to 117 and 109 and 352 of the DNS also. Both are husband and wife. Fight between husband and wife take place.
Daughter is the informant of the case.
Yes.
And she has alleged that how the father has beaten the wife.
Actually,
And she suffered grievous injury.
इसमें इंजरी में क्या है लॉर्ड
थोड़ा शर्म करिए, बेटी एफआईआर कर दीजिए।
डायरी कॉल कर दिया जाएगा। एक्चुअली में क्या मैटर को देखा जाएगा।
मैटर हम
पहले इसमें एक्चुअली में फाइट बिटवीन हस्बैंड एंड वाइफ इस कारण से हुआ, डायरी में आया है क्योंकि वाइफ का अफेयर के लिए ये बोल रहे थे हस्बैंड, इसी कारण से लड़ाई झगड़ा हो गया। वो धक्का देने से गिरी है। अभी भी वाइफ हस्बैंड के घर में ही रहती है। इनका खटाल था, 5 गाय थी, इसमें 3 बेच।
शांति से रहने की और the learned counsel
तो डायरी कॉल कर दिया, देख ले डायरी में आया है लॉर्ड।
not required for the learned counsel
इसमें चार्जशीट भी सबमिट हो गया।
कोई बात for the learned counsel
इंजरी में देखा जाए सिर्फ फेस की स्वेलिंग है लॉर्ड। एक बार तो पास लिया जाएगा।
for the learned counsel
बिना पूरा
बस आपका पूरा बहस हम सुन ली। For the learned counsel appearing on behalf of the petitioner, the learned counsel for the petitioner submits that there was a fight between husband and wife, primarily on the ground that the wife was having extramarital affair. He submits that upon a push, the wife fell down and she suffered grievous injury. And charge sheet has already been submitted. The petition is in custody since 27/5/2026.
अभी भी हस्बैंड के घर
आप हैं respondent? आप हैं respondent?
नहीं,
The learned counsel has, for the state, has opposed a prayer for them. Upon going through the FIR, the same has been filed by the daughter of the petitioner, giving vivid description as to how the wife of the petitioner was assaulted. The impugn order reveals that the wife suffered grievous injuries in view of the direct and specific allegation against the petitioner. whose wife suffered grievous injury, and the FIR has been lodged by none less than the daughter of the informant, who happens to be the eyewitness of the occurrence. This court is not inclined to enlarge the petition on bail is rejected.
Item 16, BA 6913 of 2026.
66C or 66D of ITA.
Custody comes.
Custody fees charge 26. चार्जशीट में सब कन्फेशन में नाम आया है उसमें कन्फेशन में नो टीम में मतलब
The learned counsel for the state is directed to seek instructions and file a counter affidavit in this case, indicating the materials connecting the petitioner with the alleged offence. क्या रिकवरी है आपके पास से?
ना कुछ भी रिकवरी नहीं है मेरे पास से, और ये जो भी क्राइम हुआ है वो एक्यूज्ड का ही सारा अकाउंट नंबर, मोबाइल नंबर, एटीएम सारा उन्हीं के पास है। मेरे पास कुछ भी नहीं है। मेरे पे
the counter affidavit should clearly indicate with respect to the criminal antecedent of the petitioner, the cybercrime violation. The counter affidavit be filed by 21st, post on 23rd. Let the case diary along with its enclosures be called for from the consent.
Item 17, BA 6921 of 2026.
Allegation number. This is in FIR section 64(1).
Who has lost the FIR?
The prosecutors alleged herself. When I am doing bail, the police paper has been received by me, madam. I've got the police paper and the list of events, madam. Lordship will just appreciate it. I'm giving one to him also. One of the dates are very relevant. The FIR starts at page number 15, madam.
The state is directed to serve notice upon the informant of the case and file a counter affidavit in this case on merits. Let the statement of the victim recorded under section 183 BNSS be filed for the concerned court along with the case diary and its enclosures.
And the police report is there itself.
Original records today. The counter affidavit be filed by 21st, post on 25th August.
Item 18, BA 6925 of 2026.
Child is, what is the age of the victim?
Age 17 years at the allegation. The allegation that that this man is the victim and got married with her. And further, it is alleged by the informant that on 13/1/2026, when the informant and his family member went to the residence of the petitioner, they found that petitioner already got married with the victim, and petitioner and his.
How could he marry a minor? How could he marry a minor? Or the learned counsel appearing on behalf of the petitioner. The learned counsel for the petitioner submits that the petitioner was, on the date of occurrence, the petitioner was aged about 17 years. And when the
164 she has specifically stated that on her own schedule she solemnized the marriage with the
he submits that when the informant went to the house of the petitioner, he found that the petitioner had married his daughter. And the petitioner did not allow the informing to take the victim and adduced the informant. The charge sheet has been submitted under section. Under which section?
96, 137, and charge has been paid.
Boxo?
Charge has been
Boxo है कि नहीं है?
charge has been framed under section 96, 137(2) and 8 of POCSO.
Charge has been framed under section 96, 137(2) and 8 of the POCSO. After hearing the learning counsel for the petitioner and considering the direct allegation that the petitioner married the minor daughter of the informant who was 17 years of age and also did not allow the informant to bring the victim. This court is not inclined to enlarge the petitioner on the administrative.
Item 19, DA.09.28.2026.
इसमें डायरी निकाला रीस्टेटमेंट में victim has not said तो जो allow के बारे में है वो पैराग्राफ 21 में क्लियर कट है कि नहीं है मतलब ये सब कुछ हुआ ही नहीं है क्या ये क्रॉस रिलेशन
victim का कोर्ट में एग्जामिनेशन कराइए इसके बारे में
11 days का डिले भी है
इसी में आप कैसे
अदर
नेक्स्ट केस में आप नेक्स्ट केस में एक इसमें
पहले वाला नहीं
कोई बात नहीं सर विक्टिम का आप गवाही कराइए उसके बाद
that may be recorded मतलब
it need not be recorded victim अगर मान लीजिए कुछ आपके अगेंस्ट में कुछ
victim तो 164 में भी नहीं बोली है 161 में भी नहीं
कोई बात
एंड डायरी
माइनर के साथ शादी की है कुछ
मेरे पास है चार्ज फ्रेम हो गया डायरी मेरे पास है इसमें साफ है
पॉक्सो में हुआ है ना चार्ज फ्रेम
है
पॉक्सो में चार्ज
फ्रेम हुआ है बट क्वेश्चन है कि charge is also vague, my lord.
That's
because she has already married and my lord, she is living together.
कोई बात नहीं उसका गवाही कराइए
उनके पिताजी 10 दिन
गवाही कराइए चार्ज फ्रेम हो गया है विक्टिम का गवाही कराइए एज पर द पॉक्सो एक्ट 1 महीने के अंदर उसकी गवाही होनी चाहिए पता है कि नहीं पता है आपको कराइए विक्टिम का गवाही आप गवाही करा के लेकर आइए इसके बाद ही समझेंगे विक्टिम का
गवाही तो प्रोसिक्यूशन कराएगा
प्रोसिक्यूशन आपको नोटिस देगा ना नहीं देगा नहीं विक्टिम को नोटिस देगा ना तो होगा गवाही
प्रोसिक्यूशन हैज टू एग्जामिन
दे विल एग्जामिन
cases under section 103 and 3(5) of BNS Lordship. Allegation against the petitioner along with other property persons he committed the murder of informant's parents Lordship. However, in this case, he is not named in FIR. His name has been surfaced confessional statement of the Lordship. In this case, Lordship
is not named in the FIR. The counsel for the state is addicted to 5 count affidavit.
2 count.
5.
Four person have already granted bail also. One I have made an annexure to page number 16 to 7.
इनके अगेंस्ट में क्या है petitioner के अगेंस्ट में रिकवरी क्या चीज का रिकवरी blood stained eggs and blood stain दोनों क्या आपको भाई केस डायरी है ना आपके पास क्या बोलना है
Lordship, इसमें मेरा criminal understand भी नहीं है और दूसरा बात है Lordship, I have been custody since
25/11/2025 and charge sheet has been submitted lordship 23/3/2026 lordship. And moreover, 2 co-accused persons have already been granted bail. One I have made an
चार्ज फ्रेम हो गया?
charge frame होने वाला है, charge frame नहीं
होने वाला नहीं हुआ। किन दो कोई चीज का बेल हुआ? इसमें नहीं लगा है?
उसमें लगाए एक का एक और हुआ है।
Then इसमें डेथ किसका हुआ?
इंफॉर्मेट का पेरेंट्स मम्मी पापा
समझिए, इसमें भी कोई चीज का बेल दूसरे को भी तो रेगुलर दूसरे कोर्ट को वो नहीं था ना। हाँ तो कैसे लगा? और ये वाला केस मेरे पास क्यों लग गया? वही ना, आप लोग को तो कुछ नहीं पता है, तो हम लोग ऑफिस से पता कर रहे हैं, इसीलिए इनसे बात कर रहे हैं, आपसे नहीं बात ना। स्टेट को पता है ना, आपको पता है ना। आखिर ये स्पेशल अलग से बाइफर्केशन हुआ है किस लिए? कि एक कंसिस्टेंसी हो, कोई भी उसका बेल सब जगह एक जगह जाए, इसीलिए ना। और अगर इसका कोई पर्पस ही नहीं सॉल्व हो रहा है तो हम लोग को समझना होगा कि कहाँ गलती हो रही है। आपकी कोई गलती नहीं, आप एक्यूज्ड हैं, स्टेट की कोई गलती नहीं, इनको पता नहीं है, उनको तो मालूम नहीं, जानते नहीं वाला हिसाब नहीं है ना। ऐसे कैसे होता है? कुछ केसेस वहां लगते हैं, कुछ केसेस यहाँ लगते हैं। या तो मेरे असाइनमेंट का होगा या उनके असाइनमेंट का होगा, दोनों के असाइनमेंट का तो नहीं हो सकता है। क्या समझेंगे इससे हम क्या मतलब निकलते? इसीलिए हम लोग अपने ऑफिस से ही पूछते हैं, आप लोग से पूछना पड़ता है। Or the learned counsel secretary on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since 25/11/2023. Charge sheet has been submitted on 23/3/2026 and charge has not been paid so far. The learned counsel submits that the name of the petitioner has transpired in the confession statement of court and there is nothing intimating connecting the petitioner with the alleged offence. He has also submitted that two co-accused, namely Birsa Pahan and Jailal Munga, have been enlarged on bail by coordinate bench of this court in BA number 5435/26 and in BA number 6758/2026. The learned counsel for the state has opposed the prayer for bail and has submitted that on the basis of confession statement of the co-accused, the murder weapon, that is blood-stained X and blood-stained tono, was recovered, which was kept in a concealed manner behind the bushes. After hearing the learned counsel for the parties and considering the fact that on the basis of confession statement of the petitioner, the murder weapon is said to have been recovered, the case of the petitioner stands on different footing as that of the co-accused persons, and assumption was made with respect to the co-accused persons that they were implicated only on the basis of confession statement of the present petitioner. Since there is recovery of murder weapon on the confession statement of the petitioner, this court is not inclined to enlarge the petitioner on bail and submit.
इसमें नेगेटिव प्रूफ नहीं हो रहा है, आपका स्टडी में बहुत दिन से है।
बहुत दिन से नहीं,
1 साल।
मर्डर में कितना सजा?
तो लाइफ
आप बताइए, चार्ज भी नहीं फ्रेम कराए हैं,
डायरेक्शन दे दिया,
चार्ज फ्रेम होता तो हम डायरेक्शन दे देते, चार्ज ही नहीं फ्रेम हुआ तो क्या डायरेक्शन?
Item 20 BS 6929 of 2026.
committed under section 65 of the harassment process of the person. Thereafter, charges have been submitted and charged is in 26, 20,
It is 8
26.
years old.
Yes, yes. And the accused is referred to the Chachela Dada of the victim.
FIR पढ़िए ना.
Please sustain us. मैं सुबह की धन्यवादी हूँ. आज दिनांक 18/3/2026 को मैं अपने घर से कुछ दूर पर मेरा जमीन है वहाँ पर अपना घर बनाने के लिए काम कर रही थी और अपनी 25 सदस्यों को अपने मिट्टी वाले मकान में छोड़कर गई हुई थी. इसी क्रम में मेरी घुटने की बात सुनसो मुझे करीब शाम 5 बजे के आसपास फोन करके बतलाई कि सुनसो बहुत रो रही है और चलने फिरने नहीं पा रही और मुझे बुला रही है. तब मैं अपनी घुटने की बात सुनसो को बोली कि मेरी बच्ची को मेरे पास लेते आओ. जिसके कुछ देर बाद सुनसो अपने साथ मेरी बच्ची को मेरे पास लेकर आई. तब सुनसो मुझे बताई कि दास मेरा भतिया में ससुर लगता है सुनसो के साथ गलत कर दिया है. तब मैं अपनी बच्ची को पूछताछ की तो मेरी बच्ची मुझे बताई कि अपनी सहेली के साथ का पेड़ से कुछ हो गई थी. उनका जो बच्ची का दादा लगता
The
है.
state is directed to serve notice upon the informant of the case. Let the statement of the victim recorded under section 183 be called for from the concerned court along with the case diary and also the medical, including its enclosure, including the medical examination report. FIR कब का है?
FIR 18/3/2026 का है. सेकंड चार्ज फ्रेम हो गए 20/6/2026.
The counsel for the state is also directed to seek instructions from FSL Ranchi with respect to the examination of the samples which has been sent and produce a copy of the report before this court. Post this case on 27, the counter affidavit should be filed by 24. Report the seal cover. Seal cover.
Appearance. Item 21, BS6931 of 1026.
Its allegation is with respect to assault and calling the woman as died. The FIR is at page 16.
The informant is the eyewitness of the offense.
Yes, everybody is the eyewitness because they were party to the assault. Normal actually.
नहीं, informant में भी कोई counter FIR नहीं है.
Yes, my lord. That is the case
Where
and
is that
counter
counter
case.
case? Where is that counter case?
That is there in the argument. If the lordship says, I can bring it on the court.
Counter case तो हुआ होगा ना?
इसमें पहले से भी इनके बीच में लिटिगेशन चल रहा था जमीन जगह को लेकर के. And at the same time, my lords, may I apprise this court about the fact that during investigation, lords, the wife has also given the statement, and in her statement, there is no averment of she being called Diane. At the same time, she has clearly mentioned that these two petitioners had fought with her, but the assault which was done to the daughter was by Sakaldev, who is not the petitioner before your lordship. That is the only one grievous injury that was sustained by the daughter. All and to the wife, my lords, there is only abrasion. There is no injury at all. That has come during investigation. That is there. At the same time, the police has also stated that this is not a case fit for 3 and 4 of Diane Witchcraft Act.
Saldev guy, Sakaldev guy.
Sakal, sorry.
Is he named in the FIR?
All the 3 persons are named in the FIR.
One is Lal Bihari Rai.
My lords.
Other is Saldev Rai.
Saldev and Yogendra Rai. So Lal Bihari and Yogendra are son and father.
Assault किसने किया? Saldev Rai.
Saldev. There is only one injury sustained by the daughter, which has been attributed to Saldev.
Who has said so?
My lord, the wife.
And from where do I find it?
If I may present the case directly also, because if I may, my lord.
आपका चार्जशीट हो गया?
हाँ. stage call
But
for
there is a-
police papers assessment.
You जरा देखिए Third, the learning council's opinion on the practice. The learning council for the petition has submitted that there is omnibus allegation against 3 persons, including the 2 petitioners before this court, who are son and father. And the informant of the case happens to be the husband of the victim and father of another victim. The learned counsel submits that the statement of the wife of the informant, who is also a victim, has been recorded in the case diary, wherein she has said that the daughter was assaulted by the accused, namely Saldev Rai.
Sakaldev?
Sakaldev Saldev
Saldev.
Saldev Rai. And he further submits that the wife suffered the daughter suffered grievous injury and so on her head, and so far as the wife is concerned, she suffered simple injuries.
Abrasions only, no injuries as such.
Only abrasion. The learned counsel for the state has also perused the case diary. The arguments advanced on behalf of the counsel for the petitioner by referring to the statement of the victim wife of the informant is not in dispute. In view of the aforesaid facts and circumstances, and the statement of the wife of the informant, who also happens to be one of the victim. No antecedent.
No, I have mentioned in para 25 it is.
Here the petition having no criminal antecedent. The petitioners are directed to be enlarged. चार्जशीट हो गया ना?
नहीं बस नहीं हुआ है, पुलिस पेपर्स का वेट कर.
Item 22 BA6933 of 1026.
Allegation of victim also the informant is a victim, very ready aged about 24 years. The relationship is going on about last 1 year, and thereafter the case has been. That is the content of the FIR at page number 15.
From where do you say that the relationship was going on?
Yes,
for
Lord
last
sir.
1
As
year?
because Lord sir, it has been stated in the March 2025 में ही मेरे पति thereafter the conference was taken place and the FIR was registered on 25/2/2026 at about after approximately 1 year. It's 11 months.
It's not a case of consensual relationship. She lost the FIR when her husband came back.
That's why I'm saying you Lord. That's why when the husband of the victim lady has get information about this relationship, thereafter the case has been. That is my case.
Charge sheet has been submitted.
Yes, the charge sheet has been submitted. Lord. Charge sheet has been submitted on 30/3/2026 and he is in custody since 26/2/2026.
क्या बोलिए मिस्टर?
You kindly peruse the FIR. Direct allegation forcibly जबरदस्ती करने लगा हमला कर बनाया उसे फायदा उठाते हुए 183 also supported. इसके बाद उसी की पति का ऑनलाइन हो तो किसी का फायदा उठाते हुए राजेश भाई हमारे साथ सारी संबंध बनाते रहा तथा मैं कुछ करती थी तो मेरे परिवार को जान मारने की धमकी देते हैं। And a relationship is continuous for about 1 year.
Third, the learning council security in the application parties. The learning council for the petition submits that it appears there is enormous delay in filing the FIR. In as much as the FIR was launched from 25 to 2026 and the occurrence is of March 2025. It submits that there was consensual relationship between the victim and the petitioner, and the victim was a married lady and her husband had gone out for work. And when it came to the knowledge of her husband, the FIR was pushed. The charge sheet has already been submitted. The London Council for the State has opposed the prayer for bill and has stated that there is direct and specific allegation against the petitioner of committing sexual offense against the victim forcibly, and there is explanation for not filing the case immediately, as the case was registered only after the husband of the victim came back and she disclosed the entire facts to her husband. The London Council submits that the FIR does not reveal that it is a case of consensual relationship. After hearing the London Council for the parties and upon revision of the FIR, this court finds that there is an allegation of forceful sexual assault against the petitioner and against the by the petitioner against the victim, and there is an explanation with respect to delay in filing the FIR, as the husband of the FIR was out of station and the case was registered when the husband came back. This court is not inclined to enlarge the petition on bail on account of the direct allegation. Furthermore, this bill application is with the petition.
Item 23, BA 6938 of 2026.
Item 23 and 24 are based on week's time, as the Jharkhand Council has, due to medical emergencies, not able to be. Who is the length?
How much time do you need?
2 weeks. I will be careful.
She has not come to the court.
No. He came, but due to medical emergency, he has to go. That's why he told me.
Custody year 23/5/26. Cash pay.
Yes.
2 महीना 2 हफ्ता में हो जाएगा cash. It is at the stage of investigation. I am not inclined to that.
Your legislation may be withdrawn after and with the liberty to fresh file.
The London Council for the petitioner seeks permission to withdraw this bail application at this stage. The London Council for the state has no objection to the prayer for withdrawal. Accordingly, this bail application is dismissed as withdrawn.
With the liberty after
That is at this stage. Mr. Concern, next concern.
Next 20.
Same one.
Yes.
Signed upon the instructions of the council on record.
Item 25, BA 6942 of 2026.
Offense under section 126 2, 115 2, 181, 109, 320, 94, 374, 36, 64, 62,
You
350.
were apprehended on the spot.
No.
Was he apprehended on the spot?
Yes, my lord. As per the
As per law, he has taken committed second time offense with this lady. First of all, first time लोग प्रेशर देके उसको कॉम्प्रोमाइज करा लिया, इक्विटल हो गया। उसके बाद फिर
उसमें एक्विटल हो गया।
उसमें इक्विटल हो गया।
Second
इक्विटल होने के बाद फिर घर में आकर के मारपीट किया, इसको इंजरी भी हुआ था, चाकू लेके आ गया और उसके साथ
You are
गलत
apprehended on the spot.
इसको डायरी मंगा के देख
डायरी क्या मंगाना, आप बताइए। नहीं आप नहीं, अगर आप apprehend हुए ऑन द स्पॉट तो यही लिखा के डायरी मंगाना, आपको पता होना चाहिए ना, because impugn order is indicating that you were apprehended on the spot. Yes. Third, the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and the petitioner is in custody since 2/5/2026. Charge sheet has been submitted. And charge sheet has been submitted. The learned counsel for the informant has opposed the prayer for bail, and he submitted that there is direct allegation against the petitioner, and the alleged occurrence had taken place on the very same day when her marriage was to be solemnized. The victim also suffered grievous injury.
It had not come across anyway. Because of that, in part, I had given a statement.
injury. They are not simple injury, but he are trying to assault by knife.
Okay. Had suffered
In para,
injury.
para 39 of the case
Yes.
study also. She refused to medical exam.
That's
यदि हुजूर देखना है तो मेरे पास फोटोकॉपी है।
इनका पहले भी केस हुआ था, कहाँ है?
हम स्टेटमेंट दिए हुए
नहीं, है पर ही 444/2025
हम दिए हुए
में बरी हो गई हुजूर 12/2026
उसमें एक्विटल हुई।
हॉस्पिटल में इनको प्रेशर देके गवाही बदलवा दी, और जब सेकंड टाइम फिर इनके साथ
इसका कहानी
The
कुछ और
counsel
है।
for the respondent has also stated that earlier also one FIR was lodged in connection with the victim, in which the petitioner was acquitted.
ये 28/4 का घटना
And
है।
the petitioner was कब से custody में?
2/5/26 से 28/4 का घटना है।
Case diary देखिए, थोड़ा mismatch है, थोड़ा सा mismatch है। On the spot तो नहीं पकड़ा है।
ऑन स्पॉट नहीं पकड़ा है,
तो ये impugn order में कैसे लिखा होगा on the spot?
अभी तो यही बोल रहे थे वो ऑन स्पॉट पकड़ा है।
The counsel for the state is directed to file counter affidavit in this case. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court, along with the case diary with its enclosures.
And injury report also.
The injury report and the medical examination report of the victim. The case ID be filed by, and the counter affidavit be filed by 21st, post on 22nd. देखते हैं विटनेस क्या क्या बोला लोकल विटनेस बहुत होंगे
लोकल सिर्फ जो इंटरेस्टेड विटनेस है उसके अलावा कोई भी इंडिपेंडेंट विटनेस सपोर्ट नहीं की।
let us see the case study.
अब ये जो बोल रहे हैं
Let us see the case study.
Item 26, BA6950/2026.
हो गए
Equitable order आप लगाए हैं क्या अपना?
नहीं
Nothing for the petitioner undertakes to file a supplementary affidavit annexing the copy of the equitable order of the petitioner in the previous case. Apply for it.
There is recovery of one mobile and a motorcycle without SIM card. The accused was
One mobile and
motorcycle. No criminal antecedent. Charge sheet has been submitted. Custody since 10/4/2026. Let the co-accused whose bail was earlier rejected by the court below also. He has been granted bail on 29/7 by the court subsequently after submission of charge.
on what ground he has been granted?
No, the order is not uploaded to the status.
तो अब आपका ये oral submission form कैसे मतलब लिखेंगे?
This because after filing of this, he has been granted bail.
अभी चले जाइए वहीं से bail लेंगे।
Ladies may call for the case study if there is anything against.
आप बताइए आपका क्या allegation है आपके?
बोल तो रहे एक मोबाइल रिकवरी है एक मोटरसाइकिल रिकवरी है। कहते हैं I was committing cybercrime, I was having no criminal antecedent. Our charge sheet submit हुआ है not under not organized crime, it is under the section of 380/30.
You have no antecedent.
No criminal antecedent. Specific statement is there. Para 11.
क्या बोल?
ये fresh filing का केस है from the impugned order it appears that there are two victims lordship specifically mentioned in para 64 and 63 of the case diary that two victims have been cheated through the mobile
of the petitioner.
IMI number of this person. Page 37 of the petition.
Antecedent नहीं है इनका कोई?
No criminal.
उसके आगे भी लिखा हुआ there are two financial fraud against one IME number और 7 financial fraud against the
इनके पास
other IME है।
दो IMEI नंबर मिला है।
एक मोबाइल में दो IME, दो सिम वाला जो मोबाइल होता है दो IME है और दोनों के अगेंस्ट में क्रिमिनल क्राइम लिंक।
The learned counsel for the state is directed to file counter along with the criminal antecedent of the petitioner. Cybercrime level criminal antecedent. With the case diary along with its enclosures before for criminal consent. Counter affidavit will file by 27, post on 21st August, post on 25th.
Item 27, BA6968/2026.
FIR was brought in this case under section 292 of the PNS read with section 3, 4, 5 and 7 of the Immoral Traffic Prevention Act 1956. Lord, I am one of the customers not found in room number 302. And Lord, from my position, one mobile phone is set.
Room number
302.
302. Along with whom?
Lord, from room number 302.
आपके साथ कौन था?
Lord, one Banda Bhattacharya, Lord, aged about 26 years. And one
person was there.
No.
आपके साथ कौन था? एक जना थे? दो
Lord,
जना?
one lady, one man. Lord, allegation that Lord, Agoda police station, Lord, on receiving information that some prostitution is going on in
The
Dubai
learned
city.
counsel for the state is directed to file counter affidavit in this case along with the criminal antecedent report of the petitioner. Let the case diary हो गया ना? Judgment हो गया?
No, Lord, investigation is likely to be.
Investigations taken after the release. Not at this stage. Counsel for the petitioner submits that the petitioner was found in room number 304 along with one lady and one man.
But at this stage,
And
after,
his
at this stage,
Counsel.
after submission of the charge sheet.
counsel for the petitioner seeks permission to withdraw his bail application at this stage. And then
After
counsel for the state has not withdrawn the fair bail. Accordingly, his bail application is dismissed as not placed.
Thank you. Item 28, BS 6974 of 2026.
Kindly see and accept. Page number.
Page number? Page number 20.
90.
90. Can I?
If marriage affidavit दिल्ली में प्राइज उसके बाद एक अंडर
मैरिज एफिडेविट किसको बोलते हैं?
वहाँ पे जो एफिडेविट मैरिज से
टाइम हो गया?
हाँ एनेक्सर 3 ये आर्य समाज अरे सॉरी एनेक्सर 2 का ही पेज 21
एज कितना है बच्चे का?
एज तो ऐसे आपको इसमें दिखा रहा है डेट ऑफ बर्थ जो है 10/5/2007 तो भी 19
दिल्ली लेके गए थे? तो दिल्ली लेके गए थे?
हाँ जोधपुर से रांची लाए रांची से
चार्जशीट किसने होगा? कौन सेक्शन? ऑप्शन नंबर 1 और the limit council से पेरिंग on behalf of the parties.
दोनों शादी कर लिए एक बार बुला के पूछ लीजिए बेटर
क्या पूछना है? आप लड़की को लेके चले गए दिल्ली।
हम दिल्ली लेके गए हम भगा के नहीं लेके गए हम जमशेदपुर से बस से रांची लेके आए रांची से बस से हम एयर फ्लाइट से दिल्ली लेके गए हम किडनैप करके तो नहीं ले गए
आपको उम्र भी 26 साल है।
हाँ
आप जमशेदपुर के रहने वाले भी नहीं हैं।
हम बिहार के रहने उनके रेंट में हम रहते थे उनकी घर में हम रहते थे और जो उनके फादर मदर सबको इस चीज की जानकारी है हमारे साथ उनका 4-5 साल से
रिलेशन किसने किया?
हाँ आपको मदर 4-5 साल से रिलेशनशिप में
कब किए हैं मदर? 5 साल से रिलेशनशिप में मतलब जब वो 14 साल की थी तभी से चालू है।
अब हम दोनों आदमी हम चालू एक वर्ड अगर यूज किया है
आपका एज भी तो 26 है गैप भी तो देखिए
20 उनका भी 20 ईयर है एज अ मेडिकल
लेकिन आपका पॉक्सो में हुआ है ना।
अब मिलो 4 से ठीक है 4 से मां लिखवा दी कि मेरी बेटी माइनर है उस चीज को दे कुछ तो प्रूफ चाहिए
और ये मैरिज सर्टिफिकेट भी इशू हो गया
अब वहाँ पे आर्य समाज इशू
आर्य समाज कैसे इशू कर देगा? माइनर लोग का शादी कराता है क्या आर्य समाज? उसको भी एक्यूज होना चाहिए।
नहीं तो वो तो आपको मिलो एफिडेविट किया कराया है सभी कुछ करके उसके बाद ही शादी हुआ
वो सही बात है। सर्टिफिकेट ऑफ मैरिज वेरी गुड।
यहाँ तक उनके फादर को पता है कि हम दोनों के बीच में रिलेशनशिप
ये आर्य समाज वैदिक वेलफेयर ट्रस्ट ये 30,000 कोर्ट में ही शादी कराने का काम चलता है कोर्ट के अंदर
जो है वो मिलोट हम एक बार उसको नोटिस करके बुला लीजिए बस भी हमें नहीं कर रहे एक बार विक्टिम को नोटिस करके बुला लीजिए बाकी क्लियर हो जाएगा
चार्जशीट हो गया ना आपको
आप प्रोविजन बिल देगा अगर दोनों को बुला दिया तो और अच्छा रहेगा
I think the confirm नहीं है still under the stage of investigation as per review order detective 7
2 साल तो बोल रहे चार्जशीट हो गया 1 महीना हो गया ना पुराना What the learned counsel is appealing on behalf of the parties. The council, the state is directed to serve notice upon the informant of the case and file a counter affidavit in this case on merits. Let the statement of the victim be called for from the concerned recorded under section 183 BNSC be called for from the concerned court, along with the case diary and its enclosures. The counter affidavit will be filed by 21st, post on 25th.
बेल होता है जब दोनों आ जाते हैं
ऐसे नहीं पहले उनका स्टेटमेंट देखिए उसके बाद सोचेंगे.
Item 29, BS 6978 of
Where is she staying?
कौन लड़की
आपके घर में?
माँ के साथ
आपके घर में क्यों नहीं रहेगी? आपसे शादी हुई है?
हाँ हम शादी हमारे घर में इसलिए नहीं है क्योंकि हम लोग दिल्ली से जब जमशेदपुर आए तो हमको पकड़ ली पुलिस और वो अपने माँ के पास चली गई और इनक्विट ऑर्डर में भी आ गया. हम 11/5/2026 को शादी भी की.
Yes, petitioner.
In this case, और इसमें चार्ज फ्रेम हो गया है.
FIR पर
सेवा में
डायन भी लगा हुआ.
हाँ डायन है सेक्शन 4 में चार्ज फ्रेम पूरा इंटायर फैमिली का पूरा इंटायर फैमिली. सेवा में श्रीमान थाना प्रभारी महोदय मधुपुर जिला देवघर विषय गांव के दबंग लोगों द्वारा मेरी मां का अपहरण कर लिए जाने के संदर्भ में महाशय आग्रह के साथ कहना है कि मैं ललिता देवी उम्र 40 वर्ष जिला रहने वाली हूँ. मेरी माँ कमला देवी उम्र 65 इयर्स लगभग पति स्वर्गीय सचिन सर को विगत कल रात्रि यानी दिनांक 27/11/2025 को समय करीब 7:30 बजे शाम को गांव के ही कुछ दबंग व्यक्ति क्रमशः लखन मंडल, गिरीश मंडल, अनिल मंडल पिटिशनर तीनों पिता भानु मंडल, बजवा देवी पति लखन मंडल, गिरीश मंडल की पत्नी नामालूम, रेखा देवी पति अनिल मंडल, भागीरथ मंडल पिता स्वर्गीय बुलाकी मंडल, मालती देविया एवं अन्य 10-12 लोगों द्वारा जबरन घर से खींचकर श्राद्ध का भोजन खाने ले गया जो कि अब तक लापता है. वहां मौजूद यशोदा देवी पति चिगर मंडल काफी हो हल्ला करने लगी तो वे सभी इनको भी धमकी.
The lady has been recovered.
He has been cut into pieces. This incident, the dead body was recovered. After 2 days, on 30th, headless body was recovered from 10 kilometer away from the village. इनका ये हुआ. And secondly, जो entire allegation में जो है, ये घटना 27 तारीख का है. 28 तारीख को FIR लॉन्च होता है. उस और हमारे अगेंस्ट में पूरा एंटायर केस डायरी में कुछ भी मटेरियल नहीं है. 7x और जो ये लेडीज कर रही हैं जो इन्फॉर्मेंट है वो इन्फॉर्मेंट भी हियर से मतलब उनको फोन करके हियर से.
Informant is not here, sir.
हाँ
Informant is here, sir.
Informant is the daughter of the lady
Yes,
Milord,
she's
and
the
she
daughter
has
of the
been
lady.
informed by the other
हाँ,
person,
किसी ने
यशोदा देवी जो उनकी भाभी थी, जो घर में भाभी थी वो बताई. और उनका भी स्टेटमेंट रिकॉर्ड हो गया. ये लोग खींच के ले गए घर से. कहते हैं कि वो जो बच्चा मरा था जिसका श्राद्ध चल रहा था तुम्हारे चलते मरा. हाँ वही श्राद्ध कराने उसको ले जाके
हम बोल रहे. इनका जो एंटायर जो चीज है कि ये इसमें इन्फॉर्मेंट हियर यशोदा देवी बोलती है कि हमने हो हल्ला किया ये करके. इसके बाद उन्होंने पूरा रात भर जो फैक्ट है कहीं पे भी उसने कहीं मेंशन नहीं किया. 28 तारीख को उसने इन्फॉर्म किया अपने उसको. केस डायरी में कोई भी मटेरियल नॉट अ सिंगल ओवर एविडेंस कुछ भी मेरे अगेंस्ट में. यहाँ तक कि सीडीआर निकाल लेते. एंटायर फैमिली मेंबर और जो लड़का का जहाँ श्राद्ध हो रहा था जिनका उसमें मेरा नहीं हो रहा. हम सेपरेट नहीं आया.
इनके कन्फेशन है कि ये लोग कैसे काटे हैं और उसके बाद डेड बॉडी रिकवरी हो गया गड्ढा से. और उसके बाद एक आदमी जो 201 कंसीलमेंट ऑफ एविडेंस का था उनके कन्फेशन से जो है सो साड़ी, कपड़ा, बेडशीट, जिस एवरीथिंग हैज बीन
ये फॉल्स है कि हमारे यहाँ पे कोई कन्फेशन से कोई रिकवरी हुआ।
आपके पास केस डायरी है?
मेरे पास केस
हाँ, तो अपना केस डायरी पढ़ी।
जी जी
एक केस डायरी आपको दे दी।
इनका जो है, इनका जो ये है बता दे रहे हैं जो भी है। हम 5 तारीख को अरेस्ट हुए हैं, तो 30 तारीख को रिकवरी हो चुका है इनका। ये डेड बॉडी जो है वो 29 को डेड बॉडी रिकवरी हो चुका है। मेरे स्टेटमेंट से, कन्फेशनल स्टेटमेंट से कुछ भी रिकवरी नहीं
हुआ। बस यशोदा देवी इज द पर्सन हु इन्फॉर्म ना?
यस।
उनका स्टेटमेंट क्या है?
हाँ, इनका स्टेटमेंट देखा जाए,
उन्होंने आपका नाम लिया है कि नहीं?
इन्होंने सबका एंटायर फैमिली।
अरे भाई, फैमिली मेंबर्स का शी इज द आई विटनेस।
वो
शी वाज देयर ऑन द स्पॉट।
वो तो एक
हु वाज देयर ऑन द स्पॉट?
उसमें जो भोज हो जाता है, जिसमें इनका जो भोजन, जो भोज के लिए लेके, जब इनका एंटायर एलिगेशन को यदि माना जाए, अभी हम पढ़ देते हैं इनका यशोदा देवी का पढ़ देते हैं, हम पढ़ देते हैं। ये जिला देवघर में प्राथमिक को पूर्ण रूप से समर्थन करते हुए आगे बताई कि ये अपृता कमली देवी के रिश्ते में बाधी लगती है तथा कमली देवी का बेटा जो दिल्ली में किसी कंपनी में अभियंता के रूप में कार्यरत है, उन्होंने उनकी मां की देखरेख के लिए इन्हें उनकी मां के साथ मिश्रणा में रखा था। दिनांक 27/11/2025 को गांव के ही एक दबंग व्यक्ति लखन मंडल, पिता सचिन के बेटे का क्रियाक्रम चल रहा था, जिसमें दिनांक 27/11/2025 को शाम के 7:30 बजे गांव के ही कुछ दबंग व्यक्ति लखन मंडल, गिरीश मंडल, सेम जितना भी, अनिल मंडल पिटिशनर, बजवा देवी, गिरीश मंडल, रेखा देवी, एंटायर फैमिली मेंबर, साथ भागीरथ मंडल, मालती देवी, अन्य 10-12 लोगों द्वारा जबरन घर से खींचकर इनकी ननद कमली देवी श्राद्ध का भोजन खाने ले गए। इनका जो खाना जहाँ पे चल रहा था, इनका यदि एलिगेशन को मान भी लिया जाए तो श्राद्ध का जो खाना चल रहा था, जहाँ श्राद्ध, तो मैक्सिमम यही एलिगेशन गए, जो कि अब तक वापस नहीं आए। उस समय ये वहां मौजूद थी तथा इसके द्वारा जब काफी हो हल्ला किया जाने लगा तो उपरोक्त सभी लोगों ने इन्हें भी धमकी देने लगे कि इस बार तुम्हारा नंबर है, हम लोग तुमको भी खींचकर ले जाएंगे और जान मारकर फेंक देंगे। उपरोक्त लोगों द्वारा इनकी ननद कमला देवी पर डायन होने का आरोप पूर्व में लगाया जाता रहा और इसी कारण उन लोगों द्वारा इनके ननद को जान मारने की नियत ले जाया गया और उपरोक्त सभी इनकी ननद के साथ कोई भी अनहोनी अप्रिय घटना घटित कर सकते हैं। दैट इज द रेलेवेंट पार्ट। इतना सीम लगा हुआ है। सुबह होने पर ये इनकी ननद के बारे में जानकारी लेने लखन मंडल के घर गई तो देखी कि लखन मंडल का पूरा परिवार ताला बंद कर कहीं भाग गए हैं। उनकी ननद लखन मंडल के घर में नहीं है। इसके बाद इन्होंने इस घटना की, इनका रात का घटना है, इन्होंने कुछ एक वर्ड किसी को भी नहीं बताया, ना कोई इंफॉर्मेशन दी। मॉर्निंग में गई, इनका जो कहानी है कि मॉर्निंग में हम गए, इसके बाद ये पूरा घटना में पूरा एंटायर चीज में कहीं पे भी नॉट अ सिंगल विटनेस वाला कोई भी है, ना इनको जाते हुए देखा ना कर। एक गनौरी मंडल है, गनौरी मंडल का ये क्या बोलते हैं इसको, यूज किया गया था उनका करके, उनको लंदन कोर्ट बिलो के द्वारा बेल दे दिया। इनका एक को एक्यूज को दिया गया।
आप भी वहीं चले जाइए।
हम तो वो कैसे जा पाएंगे, यहाँ पे चार्ज फ्रेम हो चुका है और सारा चीज जो है हमारे अगेंस्ट में एक केवल इनका जो स्टेटमेंट है, एंड दिस पर्टिकुलर स्टेटमेंट इज आल्सो नॉट, कहीं पे भी उनका क्लियर कट ये नहीं है, केवल एक सर्कमस्टेंशियल का कोई चेन नहीं बनता है। कहीं पे भी ना ब्लड स्टेन है, ना मेरा कन्फेशनल स्टेटमेंट से कोई रिकवरी हुआ है, ना मेरे अगेंस्ट में कोई एक भी कोई ओवर एक्ट नहीं अल्टीमेटली। और सेकेंडली चार्ज फ्रेम हो चुका है। हम करीब उसी समय 5/12 से हम कस्टडी में, और अब लगभग 9 महीना का कस्टडी हो चुका है और नॉट अ सिंगल एविडेंस अभी तक, विटनेस अभी तक एग्जामिन हुआ, चार्ज फ्रेम हो चुका है। और अभी तक कोई विटनेस, अभी तक एग्जाम कोई मटेरियल नहीं है, केस डायरी आ चुका है, इसके सिवा मेरे अगेंस्ट में कोई केस डायरी में कोई मटेरियल नहीं, कुछ भी दिखा सकते हैं, कोई भी, ना कोई इंक्रिमिनेटिंग आर्टिकल मिला, ना कोई डेड बॉडी, कोई ना वेपन है।
आपको
और सेकंड
आपको सुन लिया ना, अब आप एकदम चुप रहिएगा, बीच में बोलिएगा तो हम एकदम बीच में ही रिजेक्ट कर देंगे बिना सुन। आपको सुन लिए, आपको केस डायरी पढ़ लिए, अब बैठ जाइए। Yes.
Lord, there is allegation that they had taken away the lady, Lord. Thereafter, Lord, the dead body was recovered. Lord, they have confessed, Lord. Subsequently, they have confessed how they they were catching the hand. This petitioner was catching the hand, and Bhagirath Mandal had cut into pieces, and they thrown in the ditches, Lord, of the Khadan. पत्थर का जो खदान वहां ले जाके
एनडीआरएफ की टीम उसको
निकाले है वहां से, खदान से वहां ले जाके
ये बॉडी का पता कैसे चला?
ये बेटा दिल्ली में जो इंजीनियर थे वो आए तो वो आइडेंटिफाई किए बॉडी को कि ये मेरी माँ का बॉडी है, उसका आइडेंटिफाई हुआ। 2 दिन के बाद माथा भी, सर भी जो है सो उसी खदान से रिकवरी हुआ, बोरा में बांधा हुआ सर से, सर भी रिकवरी हो गया। और इन लोगों कन्फेस किए कि हाउ दे हैव मैनेज, हाउ दे हैव कट इनटू पीसेस।
लोग का एक क्वेरी था कि कैसे इनका बॉडी मिला, तो इनका बॉडी किसी के कहने से नहीं मिला था, जो ये इनका बॉडी जब ये फूल गया बॉडी, तो इनका हाथ जो है खदान में दिख रहा था और उसी के क्रम में ये मिला।
मेमो ऑफ एविडेंस में लिखा है कि इस कांड की अपहर्ता कमली देवी को बरामद करने ग्राम मिश्राना तथा आसपास लगे सीसीटीवी फुटेज का अवलोकन करने के क्रम में प्राप्त गुप्त सूचना के आधार से कमली देवी का सिर कटा लाश को मधुपुर थाना क्षेत्र के गौरी पहाड़ी स्थित
और सीसीटीवी कैमरा में हमारा कोई नहीं है, फोटो ना है ना कुछ भी नहीं।
एनडीआरएफ की टीम
और
की मदद से बेदीबत बरामद किया गया।
अब बैठ जाइए। For the learned counsel appealing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and charge sheet has already been submitted. And charge has already been framed. The learned counsel has further submitted that the FIR was lodged by the informant, who happens to be the daughter of the deceased, on the basis of information received from one Yashoda Devi who used to live with the deceased, and it is alleged that the petitioner and his entire family members pulled the mother of the informant from the house and took her to have food in the last rites being performed of one of their family members. And it is alleged that the deceased was being called Diane, and ultimately they took the mother of the informant and she was found missing. The learned counsel submits that apart from the aforesaid allegation in the FIR, there is no material connecting the petitioner with the alleged offence. He submits that the body of the deceased was recovered from a pond. From the mine with the help of team of NDRF, and there is no recovery so far as the on the basis of confession statement of the petitioner. He submits that except the confession statement of the petitioner, there is nothing to connect the petitioner with the alleged offence.
And confessional statement has no evidentiary value in that.
He submits that the confession statement has no evidentiary value in that. The learned counsel for the state and the informant have opposed the prayer for bail and have submitted that the eyewitness to the occurrence, Lady Yashoda Devi, has also given a statement before the police, which is recorded under section 180 of BNSS, and she has given a vivid description as to how the mother of the informant was taken away by the petitioner and his family members, and they have been addressing the mother of the informant as Diane, and they also threatened Yashoda Devi that she was next in line after the mother of the victim, and she will also be paid in the same manner. The learned counsel submits that the witness Yashoda Devi is the eyewitness to the entire occurrence to the extent the manner in which the mother of the informant was pulled and taken away by the petitioner and his family members, who used to call her Diane. He submits that the head of the mother of the informant was severed, and her entire body was found in mutilated condition. After hearing the learned counsel for the parties and considering the seriousness of allegation against the petitioner and others who were witnessed by Yashoda Devi, who has stated that these the petitioners and his family members had pulled the mother of the informant from her house and had taken her away. This court is not inclined to enlarge the petitioner on bail instituted.
At this stage, maybe at
Always
this
at this stage.
Item 30, BS 692 of 2026.
Yes, petitioner.
Major section 109. और case and counter case between both the parties. Allegation है कि हम मुकेश यादव हम खेत में हमेशा की भांति खेत में हल चला रहे थे और
109 is what?
10307
307. Yes. Okay.
और खेत में हल चला रहे थे और एक्यूज लोग आए और हम लोगों के साथ में मारपीट।
Who suffered?
और केस एंड काउंटर केस एंड एक्सेप्ट टू काउंटर केस है मैंने और एग्जैक्टली सिमिलर सिचुएटेड को ग्रांटेड बेल मैंने
Election 2 is the counter case.
माय
आपके ऊपर क्या एलिगेशन है?
मेरे ऊपर है कि ये लोग सबको मिल करके मारपीट किया, लाठी डंडा से मारपीट है। हम विजय यादव हैं जगदेव यादव का बेलुआ प्लानिंग के तहत लाठी डंडा से लेस होकर खेत पर आया और हल रोकते हुए बेरहमी से हम लोगों पर हमला किया।
The counter case is at para number. Which is page number? Counter case para.
पेज नंबर मैंने 21
में counter case.
मैं
और ये वाला केस कौन सा है?
ये वाला केस है 68 मैंने गामा पीएस केस नंबर 68 of 25 और जो काउंटर केस है वो 69 of 20 annexer to page number 21 sorry my lord annexer 3
इंजुरी कौन सा फट किया? इंजुरी ग्रीवियस है।
हाथ में बुलाया सबको मिलकर के मारपीट के सिमिलरली सिचुएटेड को एक्यूज कर देंगे।
इनके ऊपर कोई स्पेसिफिक ओवर्ट एक्ट है क्या?
हाँ, मोडेस्टी।
हाँ?
मोडेस्टी का।
इनके ऊपर कहाँ एफआईआर है? बढ़िया एफआईआर।
विजय यादव ये पिटिशनर हैं और भाई जगदेव यादव, रमेश यादव, उदय यादव पूरे प्लानिंग के तहत लाठी डंडा से लैस होकर खेत पर आया और हल रोकते हुए बेरहमी से सभी हम लोग पर हमला कर दिया तथा लाठी से मुझे मारने लगे। मुझे 4-5 लाठी मारते देखकर मेरी पत्नी जया देवी बचाने पहुंची तो इसे भी ये लोग डंडा से मिलकर आजमाना कर मिडल पर्सन
इन लोग बुरा नियत से इस बार किया इतना देखकर चाचा राजू यादव पहुंचे तो टांगी से विजय यादव प्रहार कर दिया, जिससे मेरा बायां बांह का पीठ कट गया।
टांगी से विजय यादव ने प्रहार किया और किस पर प्रहार किया? किस पर प्रहार किया?
राजू यादव,
राजू यादव, राजू महतो का इंजरी रिपोर्ट क्या है?
Left temporal seizure on the beach head along with swelling of her
कहाँ है राजू महतो का इंजरी रिपोर्ट?
इसमें YouTube not
इंक्लूडेड में उनके ऊपर कुछ नहीं आया हुआ है।
Who has suffered?
नीचे का 4 lines
Who has therefore suffered the injury? Raju Yadav also suggests lacerated wound on the left temple along with swelling as per the report. Injury was shown to be grievous. किसका बेल हुआ?
जगदेव other cases antiseptic.
For the learning council supporting on behalf of the parties, the learning council for the petitioner submits that there is place and counterplace between the parties arising out of the same incident. And there is general and omnibus allegation against the petitioner and others. It submits that the accused, namely Jagdev Yadav, has been enlarged on bail in May number 9354 of 2025 by order dated 16/10/2025. The petitioner is in custody since?
साइट 5/2026.
इसके पहले कहाँ थे?
उसके पहले एंटीसेप्टिक के लिए
23 is in custody since 23/5/26. चार्जशीट हो गया? कब?
हम वहाँ से पता कि फॉर्म के मैंने को
And submits that charge has been submitted. And co-accused has been enlarged on bail, namely Jagdish. The learned counsel for the state has opposed the prayer for bail and has placed the FIR and has submitted that so far as the petitioner is concerned, there is specific overt act against the petitioner, against Raju Yadav, who suffered grievous injury on his head. After hearing the learned counsel for the parties and considering the fact that there is specific overt act against the petitioner which caused grievous injury to Raju Yadav, this court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after 6 months.
डायरी की भी देखी जाती है
6 महीना बाद आप
3 months कर देते हैं।
Item 31, BS 6985 of 2026.
Under section 109(3) and section 3 of the BS. FIR is that page 12.
monthly.
निवेदन ये है कि मैं दीपिका सोरेन उम्र 16 उमला की रहने वाली हूँ। कल दिनांक 4/4/26 को समय करीब 7 बजे शाम में मैं अपने घर में थी, तभी मेरा पति गोविंद सिंह, that is the petitioner number 1, to Samuel Toklo, petitioner number 2, Sandeep Suri and Arlit Suri, पिता so and so, सभी मिलकर लाठी डंडा और घोड़ा से मारपीट किया, जिससे बाएं हाथ कलाई में गंभीर चोट आई। मैं अपना जान बचाकर भाग गई। फिर उसके बाद चारों यही लोग उसी गांव में स्थित मेरे मायके जा गए। मेरी माँ सुषमा सोनी को लगभग 60 वर्ष को लाठी डंडे एवं हथौड़ी से मारपीट कर हत्या कर दिया। उसके बाद मैंने थाना भी सूचना दी। What is it, miss? Incident is of 4th April 2026. However, after a delay of 24 hours, the FIR has been lodged on 5th April 2026. And from
शाम को 7 बजे का है।
हाँ, and
Next
FIR
day
lodged
का FIR
5 अप्रैल शाम के 4 बजे का।
4 बजे बाद में FIR। ऐसा भी कोई डिले नहीं है, लोग मना भी है।
And कोई specific allegation नहीं है किसी भी petitioner के against में। And also from the FIR, it is also not apparent whether the informant saw the incident happening or she heard it from somewhere. Because currently she has not mentioned that she was present at the place of offense.
What is the nature of injury she suffered?
The informant. For that reason.
The learned counsel for the state is addicted to strict instructions and file contact with it. Statute has been cited. Bringing on record the materials connecting the petitioners with the alleged offence. Let the case diary be called for from the concerned court along with its enclosures, including the postmortem report and also the injury report of the victim. The counter will be filed by 21st, most on 25th.
Item 22, BS 6988.2026.
Kind permission, I would like to withdraw this case.
Also for the petition, seeks permission to withdraw this bill application. Also for the state of nomination to the player for withdrawal. Accordingly, this application is dismissed as well.
तो साइन कर दीजिएगा। Item 23, BS 6996.2026.
The father has filed a case of kidnapping of a daughter. Please 17 minutes. One second.
Age?
Victim at the time of offense 17 years 4 months.
And then she has been recovered.
Yes. शादी भी सब हो गया। I'm please the FIR.
Girl has been recovered.
Yes.
From your position. Her statement has been recorded under section 180.
180 में तो जो पुलिस के सामने
183 का statement.
जो लगता नहीं हुआ है उनको नॉलेज ऐसा लगा 180 कैसे रिकॉर्ड हुआ है।
The learned counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit on merits. Charge हो गया?
जी 428 करोड़।
Let the case diary along with its enclosure.
Earlier not
call for from the consent court the statement of the victim recorded under section 182 BNSS. We also call for.
One thing is also there, my lord, earlier one read was filed for passing of FIR in which girl had appeared, my lord. That is at page 13.
the counter affidavit will be filed by 21st August, post on 24th.
Read file हुआ था
Habeas corpus.
नहीं for passing of FIR because there is a love of marriage हुआ है तो
What should happen?
नहीं उसमें लिखा इसमें लड़की अपियर की थी वो बोली थी कि ऑर्डर में हम लगाए हुए हैं कि आप annexure 1 है कि हम शादी करके साथ में रह रहे हैं as because at the time of occurrence she was minor hence court was and investigation was going on hence court was not entitled to interfere.
It is purchase calculation.
17
Sir, 25th.
Item 34, DA 7001 of 10.6.
The offence under section 302 and 201 of the IPC equivalent to 103(1) and 238 of the BNS. Now, the FIR was registered against unknown person on 23rd of April 2026. Lordship may kindly see Annexure 1, page 13. The written report note at page
It is FIR against unknown.
unknown. Now, the gist of the allegation note at page 18. It is said not that the chowkidar, the informant, received an information about a dead body of unknown female was lying in a bag near the riverside.
What has come against you?
Thereafter, in course of investigation, the police arrested not one Anil, that is not on 24/4/2026, that is arrest of Anil, and his confession was recorded at 6:10 p.m. That is, I mentioned in para 14 of my petition. Then again, Lord, this petitioner was also arrested on 24/4/2026. Another person, Sokat Raja, was arrested on the same day, and fourth one is Jalesar Mato on the same day. Their confession was recorded. Now, no recovery leading to recovery, not any confessional statement leading to recovery. And similarly, one Vivek Kumar was also arrested on the same day. And Vivek Kumar approached this on court note Annexure 2, page 19 is the order passed by this on court. Annexure 2, page 19. You know, exactly the same case. Save and accept
There is no recovery on the basis of confession.
Recovery of the dead body is prior to confession. The FIR was registered on the basis of recovery of dead body. Except not the confession, there is nothing on record to suggest involvement of any of the accused persons, including the petitioner like Vivek Kumar. Vivek Kumar, I also represented Vivek Kumar in the petition report note Annexure 2, page 19. Some exactly same case as has been alleged against the other accused persons in the confessional statement. Recovery was earlier. Dead body was recovered earlier. Thereafter, the arrest and confession is later.
गाड़ी किसका था?
गाड़ी जो दूसरे का था वो तो आया है. Against Guru Ansari.
गाड़ी was of Guru Ansari.
Guru Ansari.
Not the petitioner.
After killing his wife, this petitioner has made
petitioner की wife है.
नहीं. Informant का wife.
Sorry, informant.
Informant किया केस मुझे चास में. उनकी वाइफ का बोलता है कोई अननोन पर्सन मार दिया.
The dead body was.
इनके पास से क्या रिकवरी? confession statement के अलावा?
Nothing.
No recovery.
चार्जशीट हो गया?
चार्जशीट हो गया इसलिए 24/4/26 का केस है.
For the Learned Counsel appearing on behalf of the parties, the Learned Counsel for the petition submits that the FIR is against unknown and accept the confession statement of the petitioner and other accused persons. There is nothing against the petitioner. He submits that their body was recovered prior to recording the confession statement of the petitioner and the car which was alleged to have been used for carrying the dead body has been sent for forensic examination, but the car does not belong to the petitioner. Car does not belong to you.
No, does not belong to me.
He submits that under identical circumstances co-accused, namely Vivek Kumar has been enlarged on bail by order dated 29/6/26 passed in bail number 5895 of 2026 by coordinate bench. The learned counsel for the state has opposed the prayer for bail. However, the counsel for the state, upon going through the improved order, has not been able to point out any recovery on the basis of contentious statement of the petition. After hearing the learned counsel for the parties and
there is no antecedent note, there are 22
the counsel for the petitioner has also submitted that the petitioner has no antecedent and charge sheet has been submitted. After hearing the learned counsel for the parties and considering the fact that apparently except contentious statement, there is nothing to connect the petitioner to the list of offence. The case of the petitioner is similarly situated as that of Vivek Kumar, who has been enlarged on bail by coordinate bench. The petitioner is also directed to be enlarged on bail. ये मतलब दूसरे कोर्ट में कैसे जाता है?
पता नहीं, फीमेल से रिलेटेड नहीं है, नेचुरल फीमेल का जरूर है,
फीमेल का डेथ है ना,
फीमेल का डेथ है, पता नहीं
ऐसा ही क्लासिफिकेशन है, या तो भाई मेरे पास नहीं आए
हम
या मेरे पास सब है, ये दोनों तो नहीं हो सकता,
समझ नहीं पाए,
you cannot have it
एक
like
बार
this.
लगा हाँ
एक किसी के पास एक किसी के पास, for one case it is a crime against women and for another case it is not a crime against women.
कोई जगह 302 समझ के
ये हर केस में हो रहा है.
I also fail to understand that how that case was, if it is related to female.
जो भी है classification है, there has to be some mode about it.
Item 35, DA.04.08.2026.
Yes, petitioner.
FIR is registered under section 69 of the BNS. But the victim is 33 years old, and they are related to each other. They are brother-in-law and sister-in-law. FIR is at page number 9. सविनय निवेदन पूर्वक कहना है कि मैं सो एंड सो उम्र करीब 33 वर्ष के स्थायी निवासी हूँ। मेरी बड़ी बेटी स्वर्गीय सो एंड सो की शादी सुलेमान खान रोड हैपेंस टू बी द पिटिशनर पिता सो एंड सो के साथ हुई थी। इसकी करीब 1.5 वर्ष बाद मेरी दीदी की मृत्यु हो गई। उस समय मेरी दीदी की मात्र 26
Notice why notice on the face of it? She is a sister-in-law, and she has been living with him after the death of. Petitioner is a brother-in-law. The sister-in-law has been living with him, and she is quite a mature age.
Taking care of the child of the petitioner.
Yes.
Both parties are consenting. He is 33 years old, lady, and I am 35 years old. No criminal antecedent I have stated. Charge sheet submitted. And today the date fixed for commitment of case to the court of session.
The learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that, as per the FIR itself, the victim is 31 years of age.
33 years.
33 years of
Page
age.
number 2.
And after the death of her sister, she started living with her brother-in-law, primarily to take care of the child. He submits that it has been alleged that the petitioner established a relationship with her on the pretext of marriage, and subsequently he refused to marry her. The learned counsel submits that the petitioner and the victim are close relatives, and there appears to be an element of consent. The learned counsel for the state has proposed a prayer for bail. At this, the counsel for the petition submits that charge sheet has already been submitted.
Case
and charge has been framed.
No, my lord, case has been committed to the court of sessions.
And case has been committed to the court of sessions. After hearing the learned counsel for the parties and considering the fact that the victim started living with the petitioner in his home and there appears to be an element of consent. The petitioner is likely to be enlarged.
Item 36 BS 7016 of 2026.
This petitioner is the sole named accused. The offences are 64-12, that is 476, 75-2, 318-2, and 316. It includes the offences of cheating. If the honorable court allows, I will just place the written report, which is the genesis of the case. That is at page 19. A typed written report is there of the victim. I'm just placing it because some attending facts can be gathered from there so far as the allegations against this petitioner is concerned. The first line, by so and so, her age admitted to be 20 years. आज से लगभग 2 वर्ष पूर्व मदन मिस्त्री, the petitioner before this on report, 2 वर्ष पूर्व मदन मिस्त्री पिता सचिन सच का रहने वाला है. 2 वर्ष पूर्व is important because thereafter there is no particular date. 2 वर्ष पूर्व जो विभिन्न माध्यम से पता कर रिश्ता जोड़ते हुए मेरे मामा गणेश द्वारा सचिन सच के माध्यम से मुझे नौकरी दिलाने के नाम पर 1 लाख रुपया ठग लिया. This is one part, about 2 years ago. और फोन पे हमसे बात करके शारीरिक संबंध बनाने का दबाव दिया. Another thing comes. और मेरे गांव के घर पर आकर हमारे साथ बराबर शादी एवं नौकरी का झांसा देकर शारीरिक संबंध बनाता है. This is the alleged offense. The allegation is that मेरे गांव के घर पर आकर मेरे साथ बराबर शादी एवं नौकरी का झांसा, both things, देकर शारीरिक संबंध बनाता रहा. And before that she says कि 1 लाख रुपए तक लिए शारीरिक संबंध.
जबकि जाति से पता लगा कि पहले से 2
पहले से 2 बीवियां so and so and so and so. हाँ, जब मुझे इधर-उधर ले जाने लगे तो पता चला कि another victim, her statement 164 is also there. So and so से 3,60,000 रुपया ठग लिया है और उससे भी शारीरिक संबंध बनाने के लिए उसको सचिन सच को छेड़छाड़ करने का प्रयास. She makes a statement on behalf of another victim and her 164 is there, which I will place. So and so अपने को बचाकर वहां से किसी तरह वहां से भागी और सचिन सच पति गणेश द्वारा से उसके बेटा about the other so-called victim, उसका बेटा को नौकरी दिलाने के नाम पर ठगी किया है. About this Ganesh Lohra and his son Pawan Lohra. They are also not the complainant. फोन बंद करके फरार. इसी प्रकार इसको पता करते हुए राहुल थाना के
How many cases have been instituted against you?
So far as the present case is only there.
This is the only case. You don't have any antecedent.
No, antecedent is
There is one antecedent.
one antecedent of Lohar Datta, not in relation to this cheating.
Or what later?
That is of cheating. That case is pending. And so far as this offense, the other victims are concerned, there is no other case about the other victims. Now some things which I will just try to make a submission before this court, that which creates doubt. So for purpose of the prayer for consideration of the prayer for bail is
The
concerned.
point is, if a married person is establishing a relationship,
Now the manner which
pretext of marriage,
and also on pretext of giving job. So whether in such case, so far as the offense alleged of rape would be attracted.
you see, the pretext of marriage, that cheating is apparent because the person is already married.
That is one thing. But first thing,
Are you married or you are not married?
No, he is married because his wife is swearing affidavit supporting this bail petition. His wife is swearing. Now two things. First part, the main grievance, the main grudge which appears, that on the pretext of job he has taken
Pretext and marriage.
subsequently. And the important thing is that only for the purpose of consideration for the prayer of bail I was submitting, that 2 वर्ष पूर्व and thereafter no date no time, no month, nothing is there. 2 वर्ष पूर्व, and her age is 20 years, and the place of occurrence he says that her own house in the village, गांव के घर पर. So this thing creates doubt about the whole nature of allegations, that there may be some dispute about with regard to lending of money for the purpose of giving employment and on the assurance of. But this part, so far as the allegation of the, which is the major offence for which allegation has been leveled, that becomes doubtful in view of these allegations. And now there are some so far as this allegation of sexual offence is concerned. She has not mentioned anything that was established against her will. The definition under 375 of the Indian Penal Code is concerned. There that is it. And now we have certain things to, so far as our defense is concerned. There was some.
Where is the statement of this victim?
Yes, that is 164. We have got it and we have annexed. That is page 29. Annexure 6, page 29. And it is at page 30. बर्तन मिस्त्री ने नौकरी लगा देने के नाम पर मेरा यौन शोषण किया, उसने शादी का झांसा देकर 2 वर्ष तक मेरे साथ शारीरिक संबंध बनाया. ना तो उसने वहां पर आ रहा 2 वर्ष पहले और यहाँ आ रहा 2 वर्ष तक. दिस इज अ मेजर डिफरेंस. जो ना तो मेरा पैसा लौटाया, ना ही अपने घर ले गए. And we have certain defenses. And another victim, so far another victim, her 164 is concerned, which will further falsify her allegation. That is annexure 7.
She has stated that she had taken money for the purposes.
Yes, therefore I say that taking of money, that is one part. Cheating, 420 may be there, 406 may be there. But so far as the offence of rape is concerned, that becomes doubtful in view of all the attending circumstances, and particularly when there is no force. And some things, there has been some disputes. My car has been kept retained by them, because it is a case they have caught me in the village and they handed over me to police. So if some documents are seen which
not to that extent.
Yes, can we
We
see
have
them?
seen it. Yeah, I'm
Can we
waiting
see
for
those
10
documents
minutes, Mr.
for the purpose, annexure 2, for the purpose of consideration of the bail application? Page 22, it shows that there has been some transaction, some dispute, and there has been some kind of.
No, what do you want to show by annexure 2? It is standing in the name of the victim.
No, that is the name of the petitioner, and that vehicle has been retained by the victim's family, and for that we have filed a complaint. Page 23, annexure 3, page 23. Just see for a moment.
That's right.
Annexure 3, page 23. That is made by the wife of this petitioner. Wife of this petitioner.
That's right. That case will be taken care of,
and then that is one complaint, and then another official complaint has been made by the wife of the petitioner against the present informant for the overtax committed by her for the offences of blackmailing and pressurizing. And then 2 paragraphs which we have made, which may perhaps would be required to be rebutted about the informant. That is one paragraph is paragraph 14. Paragraph 14. That is page 7 of our petition. Page 7, paragraph 14. This we have stated. This perhaps may be relevant for the purpose of the offence as alleged against us is concerned. And there's one more paragraph. Just about the information.
I'm absolutely clueless. Every time you say that one more point,
no, because these are relevant facts which may be germane for the purpose of considering.
There is a case, counter case. His wife is making allegation. How is it germane to this?
Because now the informant, her status, she was herself a married lady, informant. Then how she can say that she was lured by some person on the assurance of marriage? Could she have performed marriage? She could not have performed marriage in view of section 5 of the Hindu Marriage Act. Therefore, I am referring to that paragraph.
Where do you say that she was married?
Para 25, you have given a statement. If she is called upon, let her answer that para 25. Therefore, I refer to this paragraph.
She has stated that she is wife of such and such.
Yes.
In her application.
Yes, we have.
No, in her written report, she has stated that she is wife of such and such.
She has not disclosed. That is the reason we are saying that they are not disclosing. So concealing her identity, she has made this allegation. Kindly see for a moment paragraph 25. Therefore, we have said the credential of the informant and the in view of the allegations, because at best the allegations may make out a case of offense of cheating so far as the employment and other parts are concerned. Though we have a counter case that our vehicle has also been retained by her, for which we have filed a case and complaint to the authorities. Para 25. Therefore, I am saying so. And he is in custody since 30 December 25. Charge sheet is already submitted. His wife is swearing affidavit.
What is this fleeing away from the house of her husband? What is this?
Yes, these we have.
Some FIR has been lodged against her.
About this, therefore, we say that if the victim comes and responds, this shows the nature.
We'll see that, yes. I heard you, I'll heard you, and I will record also.
And one more thing for the purpose of it, that the custody period for 7 months he is in custody, the charge sheet has been submitted, and his wife is swearing affidavit, he undertakes to be a surety. Because ultimately he has to face the rigors of trial. And if the victim succeeds in proving the charges, he has to face the trial. We are only pressing for the suspension.
On behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and as per the allegation, the petitioner had cheated the victim and taken money 2 years back in the name of providing a job to her, and thereafter in the name of providing a job to her and on pretext of marriage exploited the petitioner and established physical relationship with her. As per the FIR, the petitioner is a married person having 10 children. He also submits that in the FIR, it has been mentioned in connection with another lady who was also cheated in the name of providing a job, and then it is alleged that she was also physically exploited. But her statement under section 164 CRPC, under section 183 DNSS has been recorded, wherein she has only mentioned about she being cheated in the name of providing a job. There is no allegation of any physical assault with her. The learned counsel submits that the victim herself is a married lady, but she has suppressed this fact by lodging the FIR. He has also submitted that the vehicle of the petition has been kept by the victim, by the family of the victim of the case, as the petitioner was apprehended in the village of the victim. The learned counsel has further submitted that the wife of the petitioner has also lodged a case against the victim, in as much as the victim has been threatening her. He submits that the petitioner has one criminal antecedent, being Kunda PS case number 91 of 2008, registered for offence under section 409, 420, 467 and 468 of IPC, in which the petitioner has been enlarged on bail and the case is pending, and it appears that the bail bonds have been cancelled for misuse. The statement has been made in paragraph 21 of the bail application. The learned counsel for the council has submitted that the petitioner is in custody for about 7 months. The learned counsel for the state has proposed a prayer for bail, and has submitted that there is direct and specific allegation against the petitioner in connection with cheating the victim and others and another lady in the name of providing a job and establishing physical relationship in the pretext of marriage, although the petitioner is admittedly a married person. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, which is also supported by the statement of the informant recorded under section 183 BNSS, and also the statement of another lady who was also cheated in the name of providing job, and admittedly the petitioner is a married person. In such circumstances, this court is not inclined to enlarge the petitioner and make him subjected.
In my submissions, I will pray for recording of one or two things. That there is no allegation that it was committed against her. In my submission, that I can
The learned counsel has submitted that there is no allegation that the rape was committed against the will of the victim. So before the
Item 37, BS 7017 of 2026.
Yes, petitioner.
The offenses of section 376 of the PC. The bail of this petition was finally rejected. According to page 14. Page 14 is the order. That was done in 1/19/2023. Thereafter, there are several development in this case.
Page 14.
Page 14. Page 2.
What is the further development? What is the further development?
Further development is that the charge in this case has been framed on 10/5/2023. And there are out of 7 charging witnesses, 3 have been examined, including the informant and the husband. They have turned hostile. I have annexed the deposition of those 2 persons. That is Annexure 3, page 19. This is actually a case between the brother-in-law and sister-in-law. And page 19 is the deposition of the
victim has been examined.
No, page 19 is the deposition.
Page 19.
No.
Page 19 is the order.
No.
She has been
Page
examined
50.
as?
Page 50.
She has been examined as?
PW2. No,
Yes,
page 17. She has been examined at PW3. Page 17 is the victim.
She has supported?
No. Can you see the Pratirakshan Bachao controversy? Hindi Bhasa.
What you say?
Yes, ma'am.
The victim turns hostile. And another witness has also turned hostile. You are in custody since 10/5/23.
29. That is 29/2022. That is 3 years and 11 months.
For the learning counsel appearing on behalf of the parties, the learning counsel for the petitioner submits that the bail application of the petitioner was earlier rejected in bail number 5560/23 by order dated 19/9/2023. He submits that the petitioner is in custody since 29/2022, and out of 7 charge-sheeted witnesses, only 3 have been examined so far, including the victim herself, who also was the informant of the case. He submits that the victim has turned hostile. Another witness has also turned hostile. The learned counsel for the state, though has opposed the prayer for bail, but the aforesaid submissions are not in dispute. After hearing the learned counsel for the parties and considering the custody of the petitioner and that the victim herself has turned hostile, the petition is submitted to bail.
Item 38, BS 7021 of 2026.
Cyber matter.
Custody का
कस्टडी हो गया 13/5
चार्जशीट करूंगी वो आवाज
डायरी आ जाएगा।
अब अपने आराम से नहीं, ऐसे नहीं होता है ना। ड्यूरिंग द पेंडेंसी ऑफ अभी इन्वेस्टिगेशन कंप्लीट नहीं हुआ,
2 सप्ताह के
नहीं
2 महीने ज्यादा
हम
2 महीने ज्यादा तो पास ऊपर कर दिया, हम वेरीफाई कर लेते हैं।
क्या वेरीफाई कर लेते
फिर चार्जशीट हुआ है कि नहीं।
आइए वेरीफाई करते तुरंत आइए वेरीफाई करके। आपको तो पता लग जाएगा, नेट में ही पता लग जाएगा वेरीफाई चार्जशीट हुआ कि नहीं। आपको नेट देखना नहीं आता?
नहीं हम
आइए हम वेट कर रहे हैं, हम वेट कर रहे हैं, कल नहीं। Counsel for the petition submits that he shall inform this case tomorrow as to whether the charge sheet has been submitted or not. And if charge sheet has been submitted, she will provide the date of submission of charge sheet.
Item 39, BS 7030/2026.
Yes, ma'am. Online? Yes. Yes, petitioner.
Your Ladyship.
Yes, tell me.
This is an application for grant of regular bail in connection with Ramgarh PS case number under section 69, 351 to 352 of the BNS. Ladyship may kindly come to the first information report, that is at page 21, my lord. It's a type first information report. May I read?
29.
21.
21, yes.
21. Ladyship,
Yes, sir. Yes, read it.
ले सभी ने निवेदन पूर्वक कहना है कि मैं सच एंड सच
आपकी यूनियन नहीं पढ़ लेगी यहाँ पर। Can you read it? Read it.
the file is
अभी
not with
ऑनलाइन
her,
में
my
कितना ये FIR सुनेंगे इस तरह का file?
file is not with her, so the problem is
So,
there.
I don't want to hear
Sorry,
it.
I will only read it, my lord. थाना कोडरा जिला हजारीबाग के रहने वाली
Just a moment.
मैं वर्ष
Just please hold on.
मैं वर्ष 2003
Just a
में
moment.
अपने गांव
Please
के
hold
ही
on. Please hold. I have a file. The photo and the video has been recovered or not recovered?
Nothing. It continued from 18/3/2023.
Charge sheet has been submitted under which section?
69.
Only 69.
69 and 341.
From where do I get this? From where do I get this?
No, the charge sheet has been submitted or not, because 90 days has not been completed, madam.
So investigation must be still going on.
Investigation.
So I just want to know, video etc. has been recovered or not recovered?
No, that has not been recovered, because I talked to the trial court lawyer where the case that he was called for. This was the specific question I have taken instruction, my lord, that nothing has been recovered.
Petitioner submits that.
And if Lord
Just a
Ladyship
moment.
will kindly see the
Just
tenor
a
of the
moment. Just a moment. Counsel for the petitioner submits that although it is alleged that certain objectionable video was made viral, but there is no such recovery during investigation. The state is directed to file a counter affidavit in this case and serve notice upon the informant of the case that the statement of the victim recorded under section 183 BNSS be called for from the concerned court. The counsel for the state is also directed to produce the up-to-date case diary with its enclosures post on 27th August. So,
27th August.
we'll see whether anything has been recovered or not.
Item 40, BS 7032/2026.
Yes, petitioner.
Connection with case team is the earlier order.
Then what is the further development now.
Further development now will be recently page 16, the victim will come informant has already been examined and he has been declared hostile.
Victim is hostile.
Yes, page 16.
What do you say, madam? The learned counsel for the petitioner submits that the bail application of the petitioner was rejected on merits earlier in plea number 1933 of 2025 by order dated 5/8/2025. However, now the victim has been examined and she has turned hostile. Counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the, however, the reported submission is not in dispute. After hearing the learned counsel for the parties and considering the fact that the victim has turned hostile, the petitioner is subject to be announced on bail.
So our case, item 4, DA.04.08.2026.
It's 10 years of relationship in the parties.
10 years?
Yes, that's from the family.
Yes, there has been 10 years of relationship. You are for the informant.
Yes, yes.
Is it correct?
Yes, in the FI.
Please place it.
Direct communication against this petitioner is also and 5 times possibly aborted.
So, but 10 years of relationship is too long a period.
Page 50.
Yes, please read it for me.
Samini Devi की मैं स्वयं सोनर सर skipping the first part, the address and name. श्रीमान द्वारा next. श्रीमान को सारा स्वीट करना है कि मैं कि स्वयं सो पिता स्वयं सो धनबाद जिला मुझे शादी के झांसा देकर 2016 से लेकर अब तक यौन शोषण करते रहा। इसी बीच दबाव डालकर जबरदस्ती 5 बार किया। उसने 40-40,000 रुपया करके 2 बार कुल 80,000 रुपया गाड़ी खरीदने के लिए मुझसे लिया था, जिससे उसे मुझे 1 वर्ष के बाद 1 लाख रुपया अपने बैंक खाते में वापस किया। वो कहता रहा कि चार्जशीट का just for the certified.
What under which section?
It has been 69, 351(3) and 88.
Custody.
Custody mirrors is
6/5/26. 10 years of relationship is too long. Are you for the state?
Yes. Yes.
Does after relationship FIR mean?
Photographs have been recovered, seized by the
Photograph has been seized, but charge sheet has not been submitted under ITI.
No, it's not. I have the certificate.
Or the learned counsel appeared on behalf of the parties. The learned counsel for the petitioner submits that on the face of the FIR, there has been relationship between the petitioner and the victim since 2016. And it is alleged that the petitioner has established relationship in the false text of marriage. And certain money was also taken from the victim to buy a motorcycle, although that amount was returned to the victim. The case was lodged when the petitioner refused to marry.
And his marriage was fixed. That is also the allegation.
Refused to marry and his marriage was fixed.
It's not.
The learned counsel for the informant has posed a prayer for bail and has submitted that some photographs were also made viral.
No, that's not it.
Some photographs were also seized.
Yes.
To which the counsel for the petitioner has produced a copy of the charge sheet and has submitted that charge sheet has been submitted under section 69, 351(3) and 88.
Yes,
88 of BNS and no charge sheet has been submitted under the provisions of IT Act. The petitioner is in custody since 6/5/2026. After hearing the learned counsel for the parties and considering the fact as stated in the FIR itself that there has been relationship between the petitioner and victim for last 10 years. The petitioner is directed to be enlarged on the. Okay, sir.